May pardon to mention, my lord.
Yeah.
Writ appeal of the year 2024 regarding since 2014 the petitioner having no power supply in his residential house. Matter has been admitted. And
about which year matter?
2024.
24. What it will be posted?
No, there is no date posting.
You want date?
Yes.
Choose a date from calendar in August.
August.
Because all dates are already fixed.
August.
Whichever date.
August 4.
4. All right. 4 we have posted 5-6 cases. You can put it after 4.
I have a writ appeal of year 2023.
Please inform the other side. Hearing letters, please inform the other side. So that the matter is not listed and adjourned for.
He's a retired person and the writ appeal has been filed because they.
When do you want?
I want, if your lordship will resist, that it can be listed in the month of August.
Very. Take that.
My time.
Yes, writ appeal, your lordship. Here, petitioner is dismissed from.
What do you want?
I want it may be it was not listed.
You want listing?
My lord.
We'll do that. Why arguing? Take that. Are you happy now?
No.
Or you want to argue?
No,
if your client is behind, you can argue.
No.
Others spare us. Otherwise. Yeah.
Page 3, page 4, 11 to 15, page 5, 16 to 21, page 6, 22 to 28, page 7, 29 to 35.
My lord, item 32, my lord.
32?
My lord. Can I taken up next week, man?
All right, in the second week of August.
Item 31.
Inform the other side also.
State, my lord, of the state.
Item 31, my lord.
31?
31. We are having a discussion to settle the matter.
You want time? In August? Yes.
And I can also discuss with the Lord Council for the other thing.
Okay. Thank you.
Do we record that you are going for a settlement?
Yes.
So when it reaches, we can pass on. Okay. 31.
Yes, 31 just. It is submitted at the bar that parties are interested in working out amicable settlement. First off, to explore the possibility, call this matter in on so August. August.
Billets item 33.
33?
33 billets.
Yes.
I pray for next week billets.
Next week, difficult. We'll have it in August.
Billets.
At the request now. Inform your friend also.
Billets.
Respondent number?
4 billets.
Respondent number 4.
Page 8, 36 to 39, page 9, 40 to 34.
My lord, item 43, my lord. Permitted to withdraw, my lord.
43?
My lord.
Yes. You are a counsel for petitioner.
My lord.
Learned counsel for the petitioner. Do you have a memo in your hand? Yes. Learned counsel for the petitioner seeks leave of the court to withdraw the petition. First, she has also filed a memo dated so and so, which has the following spirit. First, next paragraph. Any objection from other side?
It's the Union of India.
Union of India. Not yet served.
Any interim order?
No.
No interim order. Not served also.
No.
Okay. In view of the above, leave having been accorded, after notice. There is no objection. Can we go no objection from other side?
Yes.
There is no objection from the other side. Just call certain also.
Call kar dega after 43. I'll ask the opinion.
In the above circumstances, leave having been accorded, petition is disposed of as having been withdrawn in terms of memo.
You have signed, who has signed? The advocate on record or somebody else? Withdrawal has to be by the advocate on record. Are you able to follow? The person who is having Wakalat Tamad Learned Counsel who is having.
Das.
Her name is there.
You are Elena Das?
Yes, ma'am.
Yes, your name is there. Right.
Yeah.
Page 10, 45. Item 1.
This is regarding that re-examination. The others need to come. So that matter where the
you had asked for authenticity, etc. Yes. recall that order. We'll do that after they come, after hearing them.
Give the memo. Let them come.
Not that simple.
No, what is the matter? For filing I have gone through the records.
So they have obtained a change.
They have filed.
So you kindly look at the YouTube where they have said that we have received this from the website, received it, everything. They pretended to be the correct answer script and.
They say, but in that view,
Kindly wait for your.
I suggested the client we have to not
That's
pursue
all
the
right.
case.
No, that's a good thing you have done. But let your friend come.
May Premlad may be taken up
You inform me on the
some other day.
No, let your client, your colleague be here.
Because
You inform the other person.
I'll keep him informed. Let it be taken up.
Not another day, because you are seeking withdrawal.
Because already it is on record. The order has been dictated. Just inform the other side.
I will inform the other side.
Let them come. They will come in. They usually come. Inform your other side is Union of India.
Go after lunch.
Yes.
So whenever it reaches no difficulty, whenever they come, it can be passed. This part.
Okay.
Item 1, may
May I please, Your Lordship?
item 5.
Yes,
Lord, 1
thank
minute.
you for correcting us, correcting me. Yes, sir.
My Lord, that is one interlocutory application, that is CMA PL of 4/27 of 2023. That was listed for hearing, and on that day, this case was dismissed for default.
But
My Lord,
you have made the
my restoration, Your Lord.
it's not good to associate and label. So, yes, brother, we restore. Right. We restore part of the-
And Your
Not
Lord,
to repeat that. This Dictapi was dismissed for non-constitution by the coordinating for order dating
18/5/2023.
18/5/2023. First one. Now an application supported by an affidavit is moved to seek to be first two. Dismissal from high prosecution is not anything to happen in any court. Such a power should be very sparingly used, because that will defeat the very purpose of approaching the power. No prejudice would be caused to the other side by restoration. But of course, it should be subject to some petition, which from the council from the applicant is agreeable with. Next, the host circumstances. Favors the order speakers is and the consequence petition told to the board subject to
Writ of appeal, Your Lordship.
restored to the court subject to the appellant. What is your claim?
My Lord, he was a candidate for the post of revenue inspector. My Lord, candidate. He has secured more marks. Persons those.
Learning the law by Gladwell Williams and small an excellent book. Gladwell Williams for King's Council, AC, the law. Highest here written introduction to criminal law, 2 volume. Excellent. Okay. One book to present to clear the truths. Subject to apparent. Presenting learning the law by Gladwell Williams. No case associated, library within 2 weeks. Filling which applications shall be deemed filling which applications shall be deemed to have been rejected, and as a consequence, the appeal has been. You also read that.
Now Your Lordship, writ of appeal is there, no, private law.
Let it be restored for you to represent the complaint condition.
My Lord.
Any urgency? No urgency. The selection matter. Let us
Post has already been filled up, Your Lordship,
put
person.
this matter immediately after compliance.
My Lord, next week, Your Lordship.
Item 6,
But in this case,
Yes.
the other side, government was directed to file a counter in this matter. They have not yet filed the counter.
23 matter. What is the time described for filing of the counter in your proceeding rules? What is the time limit under the proceeding rules?
My lord, 10 days I will file it.
That's all. I'm asking a question of one. Maybe answer the question so that many people in the bar will know.
Of course, it is a appeal.
In a repetition, you are not fit.
They are filing.
In appeal also, you want to filter on it.
Well,
Provision of
that was the order, my lord. Last occasion, that was the order.
that order was given. When it was given.
It is on 6.
Okay. Meetings.
We'll file it, my lord, 10 days.
Okay. That's the question. Appeal is continuation of the
Appeal.
proceedings. And one judge may hold the domain of this one in says provisions of the given text and fairness of being able to reproduce.
Yes.
Then you whatever you will do with the suit. The broadly will apply to proceed. Look at in here, the mistake on request is granted. A period of 2 weeks for filing the objection statement is settled. Well, if it's right to find one status party, one thing said that you file and say, not filed, the obstacle.
I will
That is supposed to have the second day itself.
second itself.
That is the reason that I am working my, how you can edit them now. In the SLP, that will be the first graph.
Without.
Yes.
Item 7.
Mainly jealous.
So, yes.
The order passed by the Honorable Single Judge directing that the pending bills of the respondent number 1 and the security deposit should be returned. Bills and security deposit of the respondent should be returned. My lord, it is arising out of a contract. My lord,
Contract for what? Transportation.
the transportation, where the transportation, my lord, he was a, my lord, this is wheat. He was given wheat for transportation, having seal mark of Punjab government, stencil mark of Punjab government. Now he delivers part of it. Then subsequently on the next day in a different truck, because your lordship knows the trucks and everything are fixed, because lest there may be misappropriation on the way. She delivers part of it with MP statement, which was never loaded in the truck. Out of 14 trucks, he only delivers 5 trucks. Then on the next day, some trucks with MP statement, and the balance he doesn't deliver. Thereafter, my lord, what happened? A criminal proceeding was initiated against him for misappropriation. EC case, which is initiated if there is any violation of the conditions, because he misappropriated personal affairs.
Reach out.
Wait,
No, that will be some proposition of sheet.
now it is like this.
You said criminal case.
Criminal case, breach of trust, breach of trust. Breach of trust, that is 407, 409, 109, 120B, it is there. Then EC case was initiated. EC case is initiated whenever these kind of deviations takes place. So grateful and PDS control order is framed also in terms of section 3. Now, as per the terms of the agreement, it also provides in clause 18 that there can be forfeiture of security and compensation can be recovered.
Security can be paid. Plus compensation, that means damages can be
Recovered.
recovered.
So grateful, man. That is there. Now, my lord, he filed a writ petition challenging the EC proceeding. There we are not parties.
They are doing the execution.
That is collector and others. Now what happens?
Yes.
But that writ petition got disposed of with a stipulation that if the EC case is not disposed of within a stipulated period, it will be deemed to be terminated. So far as the criminal case is concerned, there are other accused persons, one of them challenged, against him the proceeding was dropped, not against the present respondent number 1. But he pleads as if against the present respondent number 1, the criminal case has been dropped. That is not correct, not borne out from record.
Many accused.
Now, he files a writ petition praying for this return of the security deposit and other bills.
On the assumption that these are
Not only that, he says since the EC case is also deemed to be terminated, so therefore he is entitled to. My lord, in fact, your lordship may pardon me, I have not brought it. My lord. Honorable Judge from Calcutta High Court, my lord. Apex Court, he went to Apex Court, my lord.
Which covers broadly the fact finding sounds well.
We'll throw light.
My
Yeah. Just
Now-
look into and come back.
Tomorrow we have this.
lord.
And Mr. Misra, what is the consequence of EC?
Even if the EC case is dropped,
Yes.
the clause of the agreement with regard to our recovery will survive. That was the contention for the Honorable Single Judge. Now that has been negative and direction has been issued.
And suppose EC case is attends finality. It is a debarring of or it's a punishment or
Absolutely not, because they will stand in different parameters. That is my submission.
Do you have section 5(6) with you of EC Act?
Yes.
There is one provision I vaguely remember. Long ago I had seen, maybe my memory is playing trick with me. Subject to correction, I am telling you. Where criminal case ends, then you cannot forfeit. Just read that section. I am not very sure. That sections or EC order, there is such a provision.
But this is, your lordship is possibly referring to effect of orders inconsistent with other enactments.
Yes, just read that.
Any order made under section 3 shall have the effect notwithstanding anything inconsistent therewith contained in any enactment other than this act, or any instrument having effect by virtue of any enactment other than this act.
What will happen?
This says that even if there is something inconsistent in any other enactment, this order will have...
overriding provision.
Yes.
Is it not? This
Yes.
is Henry VIII clause, notwithstanding anything. But there is one section which says if you succeed in criminal proceedings, there is some provision. I vaguely remember. Therefore, I confessed.
That since your lordship is bringing it tomorrow, I will just get back on that point also.
Yeah.
That's what I
He was one of the members of he authored that judgment.
I am only praying, since your lordship is calling it tomorrow, one IA has been filed that is not on board. IA 3.
Registry to put
IA
all
3.
applications filed in the case. As they are.
That is today file. I have given the number.
It said all applications.
Objection.
Outcome is party.
and to check in the registry that the IA is sent to the concerned.
My lord, IA has already been numbered. Already
We
numbered.
give the number to the court.
I am giving it.
IA number 3.
3111 of 2021.
See that number.
Right.
Who is the opponent? Respondent?
She has just, no, the private respondent has also, I think, entered appearance, though not on caveat. I have a copy for her, but she is not
copy.
I'll give copy.
We will inform that matter is coming tomorrow. Yes.
Obliged.
Item 8.
Writ appeal, my lord.
Yes.
Honorable Single Judge order
Page 40.
page 44, Annex 7,
Challenge before the Honorable Single Judge is the order of punishment in a departmental proceeding.
What was the misconduct? What is the punishment?
Yes. Misconduct, my lord, it is quoted in page 41. In the same input order of punishment. Let's see, got it, my lord.
Petition of appeal.
Yes, my lord. Petition of appeal.
You can say it, yeah, no, we believe you if you say.
Yes, ma'am.
Any constraint for answering the court's question? No constraint.
No constraint.
Yes, we are asking you, what is the misconduct?
There was no misconduct, my lord.
No, Mr. What was the charge?
Charge, my lord. Disobedience of order of government violating guidelines for recording of PAR.
Page 15. 1.5.
Forging and impersonation as controlling officer. You also got it, man?
Yes.
Third, submission of false information to higher authority and
No, actually, the imputations are above that. That he recorded his reporting.
Yes,
Marks
ma'am.
in the PAR.
Yes, ma'am. That is, ma'am.
Appraisal report. Appraisal report.
Yes, ma'am.
These are ACR.
ACR, my lord. My
no official power to forgery and impersonation as controlling officer. Mislead the hearer of what is to PAR. 11 to violating the guidelines for record. Who is the recording of what you call it? You are recording.
Yes,
that is reporting, reviewing accepting and reviewing. Accepting.
Yes, ma'am.
Accepting and reviewing. Our state. Free authority. Same scheme.
Let me clarify, my lord. That was total false allegation. I called for the PAR under Act before the inquiry officer has submitted it, and that was exhibit 3, and I have given that in at page 24, my lord.
24.
Page 24. That was the my lord. No, nothing. My reply is nothing. I have never submitted such PAR, my lord.
You did not enter at all.
No, my lord.
Did you make entry of
Nothing, my lord.
Yeah.
No enter. So that is my reply.
What is your stand in response to Article 1 and 2 in page 16? What was your response?
My response is total. Then I have never submitted PAR, my lord. That is.
Charge appears to be disobedience of order of closing. If not,
I have said, in case of appellate, my lord, in the charge memo, there are two, let's see,
Mr. Malik, this is a peculiar case. Peculiar case because the PAR is of a Group B officer.
yes, group B
So
officer.
You are not holding a Group B.
I was in charge of, I was never,
You are a low rank person.
low rank and that of the delinquent?
no, my lord, no rank, same rank officer.
Same rank.
Same rank officer.
Can you read page 16?
Page 16, my lord. Yes, ma'am. Article 1 and 2.
No, Article 1 and 2, but you have to read 10 lines from the bottom. Though the delinquent officer is junior.
Yes, my lord. Though the delinquent officer is junior than Sri Sethi in the cadre of class 2, and Sri Sethi was holding the higher post. This is wrong, my lord. I have replied.
Yes. Have your very good comments.
Post, then the delinquent officer, he has submitted power of Sri Sethi as reporting authority for the period from 1/4/2011 to 31st March 2012 to reviewing authority, violating the guidelines of PAR rules, which is an offence committed by him against scheduled caste officer, and also it violates the section 3(9) and 3(10) of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. He has also falsely and forcibly reported the power of 61 officers, other officers, AHOs, for which he is neither authorized nor competent under the law. This was the allegation, my lord.
So, out of the 62 PAR,
Yes, ma'am.
it's a huge volume being reported to. Who reported that reviewing authority made a complaint? No, where the mistake was, what the wrongdoing or whatever you call it was detected. Who detected this?
At what level?
At what level?
I don't know, my lord, but it was about 2011-12, my lord. They initiated proceeding in 2018, just before my retirement, my lord. Therefore, I approached this Honorable Court, my lord, to conclude the proceeding at least, my lord. Since I have gave the reply to the charges.
Where is your reply, sir?
I gave the reply, they didn't I have given the reply. My reply is, my lord.
What you said in the reply?
That is page 19.
19. Yes, my lord. Page 19. They didn't conduct an inquiry, my lord. This Honorable Court directed to conclude the proceeding.
Kindly take us through your reply to regarding this 61, where you have said
yes,
61 this.
That is very fast paragraph, my
In
lord.
this regard, I am to state humbly.
Yes, ma'am. Page 19.
But I am to state humbly.
Page 19, my lord. In this regard, I am to state humbly that Director of Horticulture Orissa has instructed to the office to update the CCR folders of Assistant Horticulture Officers for last 3 years for promotion of eligible officers to the rank of Assistant Director of Horticulture in the DPC meeting scheduled to be held on 10/1/2014. During that period, there were 100% vacant posts of 63 numbers of Assistant Directors and 100% vacant post of 23 numbers of Deputy Directors in the state under the Director of Horticulture. The office, that is confidential CCR section in particular, have placed the list of officers whose power was wanting before me. I beg to submit here that Sri Ashok Kumar Sethi and myself belong to Group B.
We are reading that. You can read silently. Notice.
Where is the instruction of the higher authority? Higher authority instructed you to treat the ACRs, to enter the ACRs.
That was in
After being instructed, submitted PA.
Yes, yes, ma'am. That is in the file, my lord, not ma'am.
In which file?
In the office promotion
No.
proceed.
It cannot be in your office file because kindly read page 20.
Page 20, my lord.
Yes. Court line. Bold, what you have made bold also.
Yes, my lord.
After being
instructed, I have submitted
so this is by the Director of Horticulture.
Yes,
so it has to be in his file.
Yes, ma'am.
If I understand correctly, unless it is oral, unless you say that you are oral.
Was he examined as a witness?
Yes, my lord.
Not
Report of the inquiry.
Whether DD happened.
Just we are asking.
The inquiry report itself has been annexed at page 31.
No, we are asking you. In these cases, our higher up asked me to do this, I have done this. Did you examine the higher up? Sir, did you instruct him? Did you examine? He is a star witness. Otherwise, that statement remains intact. It is not unknown that many officers will give oral instructions. But you have not stated whether it was orally instructed or it was in writing instructed.
Yes, ma'am. That he has not stated.
After being instructed, I have submitted the parts.
You should have ascertained by writing a letter. This officer is saying like this. Sir, did you instruct him? Where is the inquiry? That's the one sentence. This is how cross-examination has to happen. Wellman on cross-examination. Such a great book. Very small book. 33.
Do you know operate this? 33.
Go to 33. Roll to 33.
In the instant case, the delinquent officer.
Did you ascertain from him?
Was that they say? Further, delinquent officer was nowhere authorized by any higher authority to submit power of.
They have taken that time. But at least they should have asked him, your higher officer. He is saying like this. Is it true? God is said to have given an opportunity of hearing. God asked Adam and Eve, Mr. Adam, Miss Eve, did you eat forbidden fruit in the Eden garden? Did you ask the officer? Have you given that instruction? And it appears your client appears to be clever. He has given scope for this dialogue to take place. He should have said orally or in writing.
Yes.
Now they have denied. We have not given.
Or as you said in your records, in his records.
It cannot be. It has to be in his record, not in his.
Has he referred to anything?
That's all.
Yes.
And this is a dangerous thing. We can't accept because tomorrow everybody will take up such a contention. You may ruin the career of so many employees whom you can't place.
In the inquiry, my lord, they didn't examine any witness.
Why they should examine, sir? Section 101 is held to be applicable to disciplinary proceeding. General rule.
But they have in the charge memo itself, my lord, they indicated to examine to settle two witnesses, 4 documents.
You asserted that Sri so and so instructed me.
Yes,
I have followed instructions.
Yes.
Did you do that? You should have examined concerned officer.
Officer, my lord, how can?
You means otherwise you have to suffer that out.
No.
You can refer to something in your order also. You do not do anything. You are asking the court to guess it actually.
Not that, my lord.
No, Mr. Malik, you are the delinquent, alias delinquency is alias to you. If you do not take a stand, then can the court take its own view? That's the problem.
Tomorrow you may ruin if on oral instruction, if somebody were to make entries in the PAR, you can ruin career of a whole lot of employees.
Nothing was reported, my lord. That I have given in and I have obtained on RTA.
No, you accepted that on instruction. I have done that.
I submitted the power without making a comment. No comment was given, my lord. I have just submitted the power book. No comment was made. Their allegation I have gave a comment, my lord. I obtained on RTA Act, that is page 24 under Exhibit 3. No comment was given.
That have remained silent. You should have converted. You should have confronted that recording of Mr. Ashok Kumar Sethi, Assistant Horticulture Officer.
Of your rank.
Your rank.
That
you are
yes, same rank.
Said yes or no, you have
and you are in charge.
I was in charge as Deputy Director.
In charge official cannot take that decision. BN Bhutrad versus.
Yes, but I am on the technical point, my lord. I am on the punishment is 5% of pension, my lord. Withholding of 5% for 1 year. That was the punishment imposed in 2019.
It's correct.
And that punishment under Rule 7 of the pension rules, my lord.
The power is there with them.
Yes, that is without power, my lord.
Why do you say without power, sir?
Well,
they have power to be
contrary, sir. That's
no, my lord. 7, my lord. I'm saying 7. When there is a pecuniary loss to the government, I'm fortified with the judgment of this one report, my lord.
When this disciplinary proceeding was started? During
my
then you are reading the wrong provision, Mr. Pandit. Look at the proviso.
Yes, ma'am.
I am very clear on that.
No, ma'am.
That we will not agree with him. Other lectures are. For that, loss to the government is a precondition.
No, that's not loss.
Not loss.
It's not a precondition.
Yes, ma'am. Yes, ma'am. That is because.
Same page as far as the rules are concerned. Which rule you are referring to?
Which rule, sir?
Which rule that marks that?
Rule 7.
Can you cite the page number of our book? Do you have the same book with
Page 30.
No,
Page 30.
30. Government may withhold or withdraw pension. 2 ways.
May I read it, my lord? 7:1.
Not on that topic. Then see, then seven. The continuation is you are not challenging continuation.
No, my lord. I'm on 7-1 first, my lord. I'm not challenging continuation. 7-1, my lord.
Yeah, I thought that
Any pecuniary loss.
Pecuniary
Any
loss.
pecuniary loss.
It is quantified by judgment, division by judgment of this court, my lord.
Pension is found guilty of grave misconduct, negligence. So that punishment is not attracted.
Please.
But some other punishment,
There is no other punishment, ma'am.
then nothing can be done to you.
No other punishment. There is no other punishment.
So, Mr. Malik, there is a comma. You are adding everything to pecuniary loss. So then what is about the punctuation mark? The government reserves themselves to the right of withholding a pension or gratuity.
Yes, my lord.
Or both in full or part, or withdrawing a pension in full or part,
Yes.
whether permanently or for a specified period.
Yes.
So withdrawing, so it is not quantified also.
No.
No, kindly mark. Just then read further. And,
The government-
and of ordering recovery. So it is and.
Yes.
So it is not.
And
So what is the significance of and?
whether permanent is
This punishment along with the other. It's like
there is no other punishment. That is the single punishment. May I read it again, my lord?
Yes.
The government reserve to themselves the right to withholding a pension or gratuity.
Of withholding.
Who changes the meaning?
Right to withholding.
Right of withholding a pension or gratuity, or both, either in full or in part, or withholding a pension, withdrawing a pension in full or in part, whether permanently or for a specified period,
Then sub that
and
so
ordering recovery.
recovery along with withholding.
Yes, ma'am.
Withholding can
Yes,
be a
that
punishment.
I don't dispute it, my lord.
So that was the question from my lord, that whether the government has its power.
Restricted to first part.
Government has power, madam. Government has power, madam.
Two things. Where by way of punishment, it withdraws or withholds part of the pension.
Yes, ma'am.
It is one part. You have done some misconduct. You are now retired from service. Our only control is to withdraw from the pension or gratuity.
Yes, ma'am. Yes.
No other punishment can be imposed. You cannot be dismissed.
Yes.
No question of increments. Therefore, when there is a pensioner, pension is the focal point.
Yes.
That's the point. Withholding or withdrawing pension, simpliciter,
Yes.
5%, 10%, 90%, 100% is one thing. And as my brother Sahoo Sahab had said, and in addition to that, how and is conjunction.
Quantifiable, because
It
we
is
have
not-
already stopped.
I'm not on that, my lord.
Mr. Malik,
When
you are
either withdraw or withheld, either withdraw or withheld.
On one
Yes.
point, and they may do it only to the extent of loss caused to the government.
Yes, my lord.
That is second part.
Yes, second part, my lord.
That means
When there is no
then
pecuniary loss, my lord.
you mean to say
Yes.
there cannot be penalty at all
Yes, ma'am.
to retired employee. How this court has held. These rules are of which year?
Yeah.
old rules.
Very old.
92 rules, my lord.
92 rules.
92 rules. And this was elastic match.
How-
15 and 16, my lord.
Huh?
I have given the judgment.
Judgment you have given?
Yes. Paragraph 15 and 16. The same provision has been dealt with.
Holding?
At page 383.
381.
383.
38.
83. 383.
383.
Paragraph 15.
In 15, there is nothing which supports your argument.
Yes.
Let us see 16.
In the presence, 16, my lord.
No, which according to you, which paragraph supports you?
16, my lord.
16 is against you.
No, man.
You are reading it differently.
In the present case, the department proceeding DP number has been initiated against the petitioner under the provisions of the Odisha CC rules 19. The order of punishment passed against the applicant is only to the effect the period of suspension shall be treated as such. There is no order of disciplinary authority in the...
Read slowly, read that slowly. No order of disciplinary authority.
That is the High Court holding the petitioner guilty of any grave misconduct or negligence in duty during the period of service, therefore causing any pecuniary loss to government.
Not thereby.
Thereby.
You see, while quoting this rule 7,
Yes.
and the part they have also mentioned and para 15.
On a perusal of provisions of Rule 7 of
So
the...
then you can go back to 16. Moreover, so there is no finding of any guilt against that particular delinquent officer. Moreover, no recovery has been directed to be made from the petitioner for causing any such pecuniary loss.
Yes, madam. In this case also no recovery.
So this cannot be a precedence on interpretation of that particular thing because there is no finding and no direction for recovery.
Here also there is no direction.
Your argument is on the converse. The only punishment has to be that there has to be a finding of pecuniary loss. Then only there will be a punishment.
Yes, ma'am.
So that part it has to be straight whether they have not stated that is true.
That amounts to manhandling the rule. We have to treat the rule as it is. We cannot manhandle the rules. Judges have no such power. Now, the rule contemplates two parts. It has two parts. One part contemplates cases other than pecuniary loss. The other part, cases of pecuniary loss. Where there is a pecuniary loss, to the extent of loss, pension can be withdrawn or withheld at the king's name. In the cases other than loss, pension can be again treated. Otherwise, that would be great immunity once for all if you retire from service. Even if proceedings are initiated, you were still not retiring.
And so far proceeding is concerned, my lord.
So first point is over now. First argument is over now. Your contention is...
In my contention, there is no pecuniary loss.
One second, I'll articulate your submission. Your contention is Rule 7(1) is applicable only if there is a loss to the government and not.
Yes, ma'am.
This is first contention. Just
only to loss to the government?
One second. That counsel appearing for the delinquent employee repeatedly submits that the provisions of Rule 7(1) of pension rules.
Yes, civil service.
The Civil Service Pension Rules 1992 are invocable only when loss is occasioned to the government by the alleged misconduct and not otherwise at all. First of all, in support of this, the banks upon a coordinate bench decision in 2009-2 OLR 377 in the case of Pratap Kishore Dash versus High Court of Orissa. Second is?
Second is 1960.
No, that is not his case at all. 16 says, after retirement, what should happen? We are not on 67. Even 17, you do not say. You do not say government has, once you retire, you are out of the control. You don't say.
I was thinking that is your contention, but you say that yes, they can continue.
They can.
Proceeding can continue in way of the
Yes, proceeding can continue.
That's good.
Proceeding that continue, my lord. But one thing, proceeding, my lord. I have
Malik, just
one. I have on continuous proceeding, my lord. Regarding continuous proceeding, my lord. There, after my submission of the reply to the charges.
No, you go to the third one. Lordship is recording your submission. First one.
First submission we have recorded.
Second one.
What is your second?
Second one, my lord.
You say
second one.
That.
On second one, my lord. After submission of my reply to the charges, they didn't conduct an inquiry. They deliberately delayed it. Therefore, I approach this Honorable Court. This Honorable Court in WPC 4062, I have quoted in page 3.
Page 3 of
Page 3
your
of the writ appeal.
your petition book.
Writ appeal. This writ appeal, ma'am. Velocity got it, ma'am. Page 3 of the writ appeal, ma'am. Paragraph 5.
Paragraph 5. The modified.
The modified.
Sorry, one second. Hold it. 1 second. Petitioner in this petition asserts the order date signs pass the order directly counter right. Original application is for of not right for the is going to reside from June 2015. Place for a direction.
So the court gave the authorities 18 days to complete the proceeding.
Yes, madam. Since
18 days.
Yes. That was done by end of 12th April. By end of April.
12/4/18 court passes the order that you complete by 30th April.
And
after the matter is kept pending in the court for how many days?
Madam, then they file an IA for the extension of period, my lord. That was also rejected. I've given in page 4.
That's all right. You mean to say after period was over?
Yes.
No, the power to hold inquiry withers away.
Yes, madam.
Any judgment to that effect? Any ruling in the independent since at least 1950? Supreme Court came into being in 1950. In the last 125 years, 75 years, do you have one single ruling? Unless the order say, after that there shall be no holding of inquiry. Would have understood.
I have two judgments, one from Calcutta High Court.
Saying?
Yes, once the court directed specifying a date. After that, and one of this Honorable Court also. The division of this Honorable Court, my lord.
Holding,
once
it is said, you
the court directed a specified date. If it is not done by that date, they can't go
proceedings will lapse.
Yes.
That way?
Yes. One judgment, division judgment of this court, man. But
and your contention is contrary to Supreme Court decision 1995 6 SCC 105.
Because the Apex Court said
State of Odisha versus Kalicharan Mahapatra. Even though the charges not are of causing pecuniary loss, withholding of gratuity held value. The first contention is contrary to Supreme Court decision. 1995 6 SCC 105.
Gratuity.
Because gratuity.
Pension and gratuity.
Yes.
Both are terminal benefits.
Gratuity actually is very difficult to hold back. Supreme Court.
Because you also contributed 8.33%.
Gratuity, unless because that we had the Supreme Court decision is
that is on first contention, my lord.
No, that is on the face of a Supreme Court decision, and perhaps 2009 OLR.
This first contention is liable to be rejected in view of decision of the Apex Court in 1995 1 SCC 6 SCC 105. First off, it hardly needs to be stated that if gratuity can be withheld, logically, pension also can be. And as much as both are terminal benefits only. First off, in fact, there are some legal constraints for withholding or withdrawing gratuity, whereas there is no much of that for pension. Okay.
Next memo, in the charge memo,
the second contention is
over, my lord.
Second contention is contrary to 2007 14 SCC 41.
The second contention of the appellant that in the earlier round of litigation, the tribunal had fixed administrative tribunal.
Yes, ma'am.
The OAT.
The judgment of this Honorable Court, ma'am.
Supreme Court said in 2007 14 SCC 49, quashing of entire proceedings, departmental inquiry and recovery proceeding only on the ground of delay, then unsustainable.
That is visually. Supreme Court has
no, kindly let us respect Supreme Court Act.
Yes, ma'am.
Then 1994 supplementary 3 SCC 628.
Yes, ma'am.
High Court is not justified in refusing to grant time for concluding inquiry. Because that is your third contention.
Delay ground, my lord.
No, delay ground you cannot. Not granting time because you said that application was filed. They did not grant time. Is it not?
I could not get.
Sir, you went to the tribunal.
Yes, madam.
Tribunal on 14th of April says that you end it on the 30th of April.
Yes, madam.
So that is on the face of Supreme Court order.
Yes, madam.
Then they file a IA for extension of time.
Yes.
That was rejected. That is again on the face of the Supreme Court judgment. Order, these are all the elaborate judgments.
But that order attend finality, my lord. That order, my lord.
Supreme Court says that that cannot attend finality because you cannot do that. The limits of judicial review of these kind of things on the face of the statute.
Yes, my lord. I concede to it, my lord. I concede to it.
Please examine.
Yes.
It's not a.
Even, my lord, I have some other grounds, my lord. Even after they continued the proceeding, my lord.
Your ability to discuss.
Yes, ma'am.
So you have to reflect on.
Even conceding, they continued the proceeding, my lord. They encouraged conducted, my lord. In the charge memo itself, my lord, they relied upon, they sought to rely 4 documents. They have given in page 18 of the 4 documents on 2 witnesses, my lord. The inquiry officer did not examine any witness, don't rely upon any document, my lord.
What part they should examine? If you concede.
I never considered.
No, you say that because of higher instruction from higher authority, I have done that. That's an admission.
No, I have on instruction of the higher authority. The allegation is in the charge memo. I made some comments in the part.
That you have not denied, Mr. Bond.
On the other hand, you said I did it because higher authority instructed me. I have no discretion.
Higher authority instructed me to produce the file, firstly, but so far comment, my lord. Comment, my lord. Yes, see the again my reply, my lord.
Reply was
yes, in my reply, in my reply, I have given, my lord. Again, same page 20, page 20 of the appeal memo. Well, also got it, madam.
Yeah.
Page 20, 3rd paragraph. As per instructions of the Director of Horticulture,
I have only initiated.
I have only initiated the part of all officers, ASOs, in the capacity of Deputy Director of Horticulture, Headquarters, in the office of the Reviewer, but have not given any remark. But have not given any remark in any column except put a seal, no comment, not during my tenure.
That itself is a comment. Because you see that how no comment we'd have understood. Had you said no comment, but you have post-fixed something which is like adjective, not during my tenure. That amounts to saying something that everything is clean, something like that.
Actually, regarding Ashok Kumar, you have not denied. You submitted 62 past.
Yes.
Regarding Ashok Kumar, you made an entry.
No, madam. That is,
so again, no comments actually. The problem is no comments has a value as far as because
ACR
J department notification which you have annexed. Whenever the superior authority gives no comments, what will be done by the receiving authority, that is also defined.
No comment. You have no comment means something you are saying that everything is all right with this man. That is defined under the rule only. No comment. What the no comment means here?
So documents, they have to go through the last 3, then they are
preceding 3 years.
There is elaborate procedure. They are developed gradually.
Therefore, it is not simple 2 English words. They are not simple 2 English words. They have enormous concept.
Like suppose last 3 years is good, very good, then excellent. Most likely it will go to be very good. But if instead of no comment you give excellent, it will be very good. That is a consequence. And roughly, I'm saying because Lordship is asking what is the practice.
Because these rules they change from state to state.
Supreme Court has actually directed after the Avachit goes to the Stidar. So that even very good has to be communicated. Correct. Why it will not be excellent?
Avachit goes to the Stidar and
Sukhdev Singh.
I have given the judgment of Satyendra Singh.
Kaju's judgment.
I have given the judgment of Satyendra Singh, my lord, the Supreme Court judgment, my lord. Saying even in an expert inquiry also, they have to examine to prove it is the duty of the
examination. Sir, we understand that.
This is correct.
Question of examination arises where you deny charges.
Yes, my lord.
When you admit, where is the question of holding inquiry? You have virtually admitted the charge, saying I did these things because there were instructions from the higher ups.
Yes,
I have no discretion to disobey.
yes,
Therefore, I have obeyed the instruction. I have done this. Where is the question of holding a disciplinary inquiry? Even admitted things should be again inquired into. That runs counter to 58, section 58.
regarding giving any comment, my lord.
And Mr. Malik,
No, this itself amounts to comment.
suppose you say that director had instructed, then he would have been proceeded against. So remember, I was appearing in a matter where for delay in conducting inquiry, the officer was proceeded against.
Yes, I would. Anyway,
So he would have proceeded against because he could not have authorized it.
yes.
So you have 4 grounds now. First one is Rule 7(1) is not applicable in view of coordinate bench decision. Number 2 is proceedings could not have been held after the lapse of the period because the coordinate bench has said that way. Writ petition said that way. Number 3 is I have not made comment at all.
Yes.
These are the principal 3 contentions. 4th is if at all I have made, it is on the instructions of my higher ups.
And
Any other ground?
yes, my lord. No, other grounds, my lord. The proceeding was initiated, my lord. In 2017, my lord.
Yeah.
Relating to the par relating to 2011, no submission, 2011. After 6 years, my lord. After 6 years. In view of the MB Vigilani, my lord. Okay.
That is again explained in subsequent decisions. In subsequent decision, this decision is the apex court said it's not a thumb rule.
They are relying upon the earlier vanishing
This decision
case.
which you are now cited, the very same decision is commented upon in the subsequent decision, holding that whether there is a delay, lapse, etc., it all depends upon the facts of individual case.
Yes, ma'am.
Therefore, straightway we don't mean to say any thumb rule. Wherever there is enormous delay, no disciplinary proceedings at all. This is how apex court has treated in disciplinary proceedings.
The delay has to be explained. I got a lordship point. But your Supreme
That is regarding writing of par.
writing of
Holding of discipline, related holding of discipline.
related
That has been considered subsequent.
Subsequent.
yes, ma'am.
Apex court.
Something. Yes, the delay has to be explained. The unexplained delay, my lord.
There are things which one has to prove by oral evidence and man's memory being short. In fact, Nariman's book says before the memory fades is autobiography. Is it not?
Yes, my
There is-
last contention, my lord. The lordship to see the order, punishment order, my lord. Annex of 6, page 41.
42.
Yes, ma'am. Yes, with the punishment. Withholding 5% of monthly pension
Yeah.
for a period of 1 year.
Yeah.
That order was passed on 26/8/2019.
26/8/2019.
It lapsed after completion of 1 year, my lord.
26/8 means it comes with effect from 1/9. Because it used to be 1/9 only.
Yes, yes.
Yeah.
26th August 2019.
Correct. Therefore, it has to be 1/9.
1/9. Yes. From 1/9 2019.
Correct.
From 1/9
Effective date will be 1/9.
1/9.
So
yes,
actually
I got
taking effect will be 1/10. 1/10.
From 1 September to 1 year, the next year 2020.
No.
August 20.
August.
No. In August, he does not.
Yes.
It starts from 1st September.
1st September.
Yes.
1st September to 30th September.
Yes, yes.
So next year, with effect from 1/10, in the succeeding year,
Succeeding year.
it should be restored.
Restored, my lord. for this punishment, my lord. Till today, I retired on 30th June 2018.
Even they are going recovering everything.
No, not recovering, my lord. They have not paid any amount of salary pension, my lord.
Is it
not paid any amount of pension, gratuity, nothing is paid.
They cannot take that. We have already, in fact, cumulative effect, we have already held that it is bad, struck down.
But
sir, that is not given.
my pension is not given, my lord.
He has to take instruction, but it is unrelated.
Why pension is
They have
not
2
paid?
dates, my lord. And last 2 dates they have taken instruction.
Why, brother, why pension is not a bounty? Because of PS Nakara.
From 1/10/2020, they should have paid the normal pension. Because
not 19, 110, 2020. It is
1/10/2020
1/10/2020
onwards.
Have you paid that?
That I will take in.
What is this? All through
They should have been paid, Mala. There is no occasion to.
Even that is not paid. Nothing has been paid.
95% was not paid, he is saying.
You have completely withheld the pension is his case.
That is neither that is the letter and spirit of this order, nor it should be done.
He says it has been done.
I will take instruction, Mala.
That
So, for the
230.
110 to.
That only point, this one. Whether pension is withheld or not, what is that instruction? You have to telephone your government secretary and he should tell that.
Tomorrow?
No. At 2:30, I'm passing it over. You telephone and tell it. You send a message to him. If he answers well and good, otherwise,
Yes,
you see DS Nakara,
Yes,
what Apex Court says.
Pension is not bound.
It's not a bounty. It is not a bounty. You can't withhold. But so far as the rest of the things are concerned,
Rest of the things, it is.
Mr. Malik conclude the following 5 points in support of his case. Number 1, Section Rule 7(1) of 1992 rules is not applicable in as much as no loss is occasioned, and that it is not even the case of the opposite side that any loss has been suffered by the government. First off, in support of this, he banks upon coordinate based decision in science society. So, number 2, secondly, the proceedings which were not accomplished in terms of learned single judge's order of this court in time could not have been continued at all, since that order has attained the finality. First off, a differentiate between, all right. You don't have the immediate decision on hand.
No.
You have not made any notes. You should have made notes after seeing my brother. Of course, I have also my own notes. Yes.
Note, I have. Writ petition I have given note.
It is not. You said after period is fixed by the court. Beyond that, you cannot do anything at all. In support of that, we want it.
Yes.
Not. But delay is one thing.
Yes.
Period fixed by the court.
And
is
the
another.
difficulty is, Mr. Malik, that these decisions you are citing in by tribunal, they do not refer to any Supreme Court decision.
But order operates.
But the order is of
Order operates as res judicata is contingent. First of all, he also adds,
here if the decision is discussed and not distinguished.
he also adds that even application seeking extension of the period also was negative. And therefore that would operate as res judicata. Come on, even if such orders are wrong. First, number 3, the proceedings in question are highly belated and therefore they are liable to be struck down on the principle enunciated in Vigilani.
MD Vigilante.
Just give that
That is
citation.
2000. I've given the MD Vigilante first. 2006 5 years.
Lastly, wait down, citation. Lastly, he submits that though order of withholding stroke withdrawing the pension by way of penalty is confined to 1 year,
5% for 1 year.
by 5% at the rate of 5% for 1 year.
For a period of 1 year.
Till date, no pension is paid to him.
Pension, gratuity, full pension,
No terminal,
pension and gratuity.
no terminal benefits are paid to him, including gratuity.
Yes.
Gratuity. And this is in gross violation of what the Apex Court said in DS Nakara versus Union of India.
Stay order. Why they stopped?
They should. You have to say that.
I'll come with
Where have you taken up that contention before the learned single judge?
I have taken the part.
Is it? How learned single judge has treated it?
They have not dealt with.
We have not dealt with that one. First. Can we write down that way that you are saying?
Yes.
We will go through if it is not true. Then on that ground your appeal will be dismissed.
Let me check up my.
Check up. Don't say
Not
make
confident.
allegation against the
I'm not
judge.
confident.
Because unlike in good olden days, judge is not a responsible.
Yes, ma'am.
In good olden days, judge was asked to come and justify his order. Fortunately, that is not there. Otherwise, we would have been roaming in various courts saying that we have to justify our order. Nothing is stated. Just look into it and see.
Yes, very good.
Brother, you have not filed any objections even before the single judge. Fine.
Counter and rejoinder is there.
Counter and rejoinder has been filed.
Now, what have you stated? Where have you stated you are not you have paid any pension or 10-month benefits in your petition? One sentence saying that till date nothing is given.
No, I have not.
You are not stated. Then offhand you cannot take such a stand at all.
I have not. Because the punishment is 5% for 1 year.
Understood. We have
Yes,
understood. We have.
I think that too basic pension also. Not the total.
Where have you complained that till date they have not given us the pension at all, gratuity at all, EPF at all, PF at all,
Gratuity and lip
EPF at
salary.
all? Where is the contention?
Gratuity and lip salary they have not.
So Malik, in 15 paragraphs in read petition, you have not stated.
Yes.
In read appeal, have you stated?
No, ma'am. Rate appeal I have not. Rate appeal only
Is your client
confined.
here? Is your client here?
No, ma'am.
But on what basis you make this submission?
Or on instruction.
On his instruction.
On his instruction.
They have not received any pension. Just verify.
Yes, just.
I will verify and come to you.
At 2 o'clock. Not this matter at 2.
Yes,
One sentence you have to say. Government knows whether pension is given to employee or not. Just say this.
and pension, gratuity and lip salary.
No, any final benefit including that pension. and-
You cannot make out a case, dehorse the pleadings.
Yes, ma'am. Yes.
Outside the pleadings, you cannot make out a case because they will be taken by surprise.
Yes, ma'am.
Hopefully, given the just
Even whichever outcome. Outcome for possible. Not to some of us.
You respectfully say that the treatment of the subject is not that satisfactory. Rule 7, interpreting Rule 7 is not that satisfactory. Therefore, we have to interpret the observations of the DB now.
And the recovery is akin to that punishment of, because after post.
And is there which you might say.
Yes.
Otherwise, if we agree with your contention, the word, English word and, which separates two things, like Berlin Wall, that will fall down.
There is what grave misconduct. If is
No, but that is for second one.
yes,
For second part.
yes.
For the
In
first part.
First part, it is in first part. Pecuniary loss and a grave misconduct committed by the.
In fact, there could have been a semicolon,
Yes.
rightly speaking. Maybe that rule maker never read the Wren and Martin's grammar at all.
Yes. I agree.
It appears that way.
Yes.
He has written it as if some first year law student writes a letter to his principal.
The wording is the petition is found guilty of any grave misconduct or negligence in duty.
That comes
Yes.
after and.
Yes.
And is
After
interpreted.
and. Yes.
And is interpreted in Crawford.
Yes.
In Crawford, and is interpreted. In GP Singh, and is interpreted. At least half a dozen judgments of our Supreme Court are available. What is meant by and can be read or also sometimes.
Yes.
And can be read as or and that.
But that grave minor has not been defined in Rule 7, but it is defined in Rule 6.
What is?
Grave misconduct.
We are not on that now.
Yes.
We are not on that.
Define everything. What the court should do.
Question of grave will arise only when loss is occasioned. Otherwise, it fits into the first part. You mean to say, if we accept your contention, once an employee, a guilty employee, he retires, he will get the certificate that nothing can be done with. That's contrary to the service jurisprudence of at least 50, 60 years.
Our rule is clear, my lord. The pension is also subject to conduct, my lord.
Let's have it.
Pension is subject to conduct.
Pension rules.
That is the reason actually.
Yes. Pension is subject to good conduct, my lord.
Let us.
Item 9.
We may not subscribe to that extreme view, but you said that the pension is not at all paid.
Item 10, Miller, that series of matters in respect of the contractual appointment and the purchase distribution. I pray for a passover.
But it's covered by the judgment.
No, covered by judgment 18.6 and the other Sudhanshu Jana case, which is by the Honorable Apex Court. Learned AG is to address kindly passover.
There was one Mishra case, na?
So Anup Mishra is
Anup Mishra case, not that case. Not that.
That is
that Mr. Mohanty has argued his heart and soul, so he is satisfied now. Not all this.
only single passover.
No, absolutely no issue. Passover.
Item 11.
11, I at flag B for condonation, there's a delay of 11 days election.
Ah, 11 days.
My lord.
Served on the other side.
Yes, sir. On the last occasion, notice was issued, Your Lordship. That is on 1/5/23.
Application supported by affidavit seeking condonation of a short delay of 11 days is allowed since explanation offered is plausible. Okay. What are your merits?
Short date we fixed. I'm ready for hearing.
August we have this matter. August 2nd week. Okay.
Because
This is Retapil 714.
my lord.
30 reported delay of
39 days.
Yes, Mr. Mohanty, you have condoned the delay.
I have another file also, another IA for IA 132/425, citing the recent judgment by the Honorable Division Bench. Identical matters have been orders have been passed and upheld by the Honorable Supreme Court. Same matters.
Mr. Mohanty, is it covered by judgment?
DIXIT plus annexure.
Yes, if that is so, why we should
Annexure.
Yeah.
5 minutes.
just look into, we'll call this matter next week, Mr. Mohanty.
Annexure 14 series.
In August.
Other parties are there.
Other parties are also there.
No, Your Lord.
No other party. Only
The managing committee has no role. The government has the own.
That once the court
Already notice sufficient.
then it will be at your risk.
Notice sufficient.
that's sufficient.
Yes, in the noting.
In August, we'll have it in the second week of call him second week of August. Since it is submitted that matter like is covered by the decision of its coordinate bench, which is by the Apex Court.
Item 12.
Just look into.
Item 12 and 14 are also work charge employees regularization.
Covered. 11 and 12. Paso.
12 and 14.
Along with 12 and 14, na? Yes.
So now, neither AD nor service notice. So you have to check it. So there we cannot conclude on the basis of postal fact. So you have to wait. The report is otherwise. You said it is sufficient. You said neither AD nor unserved notice back from RTO.
Or you take fresh steps on second.
First steps, my lord.
You can take also.
In the meanwhile, fresh steps to be taken in respect of unserved respondents.
Absolutely.
Okay.
Item 13. Item 13.
13 my lord, notice was issued.
Delay of how many days?
My lord, here is the delay of only
Wait, sir. If the notice, if the June notice also, not it, sir.
Await service of notice. Okay, next. 15.
Abandon and
Seven. On the next.
Item 15.
Item serial number 12 for the petitioner, that is the employee. And I have got instruction to appear in serial number 14 also. So can I frame a related date be fixed so that?
Then we'll hear you, give you full hearing to your satisfaction.
Rather, if you want to
Articulate submission.
better he should make his submission because they are appellate.
Yes,
So
ma'am.
that
Yes, ma'am.
you respond. Because the terminus letters, they are the.
We cannot keep the matters pending, series of matters for all good employees. We cannot keep, we should tell them this way or that way. Let them not labor under an impression that some windfall will
No,
happen.
I also want.
Therefore, let us decide this matter. All are served in the matter.
The pension.
Yes, Mr. AG.
May I please, Lord, sir? That these nature of cases, in fact, a batch of cases were carried in appeal to the Honorable Apex Court. But the recent judgment rendered in State of Orissa versus Sudhanshu Jena, Lord, Your Lordship, I think that judgment might have been cited before Your Lordship. But in fact,
what the Apex Court said?
Lord, Apex Court said that the Nityanand Biswal case was not decided taking into account the amended provisions of the pension rules, especially Rule 18(6).
What is the gist of the matter?
The gist is they are all job contractors.
Job contract.
Job contract employees. I'm not in short, I'm calling them job contractors. They were appointed intermittently with casual break or no break, like this, Milord, without following the procedure under the rules. Procedure of service rule, Milord, irrelevant service rule, Article 309.
Which year?
Milord, they were appointed in various pages. Some those batch of employees, Milord.
We want to know. We want to know this because in one of the matters, the rules were promulgated only in the year 2019. And if it is pre-rule position, law is different. Post-rule position, law is different.
No, that is correct. But
we
that
want
is
to
not,
know.
No, but that is not the case, Milord. Here it is a question of grant of pension, eligibility to get the pension.
Under pension rules.
Under the pension rule.
OJS pension rules 1992.
1992. Earlier it was 77. So that was.
May I re-articulate again what fell from my head? Actually, we considered that pharmacist case. And Anup Kumar Mishra case. So there were, you went to Supreme Court. So Supreme Court has observed, interpreted 2019 rules. So your case is that they worked in different capacities and different posts as job contract.
Job contract.
So they worked in, suppose, as a peon or as a driver or as a bulia or whatever.
Etc.
Yes. So is there any rule governing that recruitment or appointment? That is the query to.
So that is under the survey settlement manual. It is not, it is under the survey. They are, all those employees. That's correct.
Is there any service rule?
No, that is under survey settlement manual. Yes.
So manual is a product of executive power.
Maybe not, because I have to examine. So that is not the case here. They say, let me just give a brief background of the.
That point is well taken. That they are seeking pension under OCS pension rules.
My lord.
But to start with, when they were engaged,
right?
Whether the prevailing rules.
No, but that is not the issue. Whether the past period, unregularized period, would be counted for the purpose of pensionary benefit. That is in a nutshell is the question. So, what happened? The case, my lord, originates from the year 1993. A batch of cases were filed originally in the High Court. In 93, my lord, the job contract employees association itself. The Honorable High Court was pleased to dispose of, directed the government to come out with a scheme. So the state government, my lord, in 1997, way back in 1997, came back with a proposal how to regulate their pension, etc. Ultimately, my lord, they were crystallized in the form of a rule, and Rule 6 in Rule 18 was inserted. It's a non-obstante provision. But I'll take your lordship to that.
97 rules. Because this 597.
No, my lord, that was with effect from 2001. No, this 97 is a government memorandum. That is of 15th May 1997. Following that, my lord, we wanted to incorporate in the rule how to calculate that period for the purpose of computation of the pensionary benefit. So, my lord, there are two classes of employees. One is a work charge. They, my lord, work under various schemes of, that is especially of the Water Resources Department. And those category of employees who are before your lordship today, were working under the consolidation.
Revenue
Department, mainly consolidation, settlement, etc. operation.
Only confined to settlement and consolidation.
Settlement and consolidation. So therefore, my lord, the question arose in one of the cases.
That rule.
Rule, my lord, I will place two rules, 18.3 and 18.6, sub-rule 3 of Rule 18 of the pension rules, my lord.
So this amendment was brought in
2001, my lord.
2001.
Unfortunately, this
2001.
My lord, sorry, 12 date 1st of September 2001.
19/2001.
Lord, may I place these two rules first? Let the Rule 18 be, my lord, placed with the entire rule.
Just a moment. Just give me. Yes. It was to pension rules.
Yes, pension rules.
It's 38.
If
It's 38, the relevant.
it is OLR publication, then that would be page 38. 18, Rule 18, my lord, the entire rule, let me place. That is the rule which deals with the qualifying service for the purpose of pension.
First one is pension rules apply where pension, it is service is pensionable.
Right, my lord.
Okay.
That is obvious, my lord. Unless it is a pensionable establishment, pension is not automatic. So therefore, my lord, let me go one by one. Service does not qualify for pension unless it is rendered in a pensionable establishment post. The entire continuous temporary or officiating service under government without interruption in the same post or any other post shall count for the purpose of pension in respect of all categories of government servants, except in the following cases. This is important. Except, these are the exceptions. Period of service is a non-pensionable establishment. Period of service in the work just establishment.
No, why number one is taken care of sub-rule 1 itself.
That's correct. That is correct. That is below positively worded. This is negative, your lordship may say. That is pensionable. It is non-pensionable. So it is not applicable. So period, your lordship absolutely right.
Work charge establishment.
Work charge, period of service paid from contingencies where the employees concerned resigns is not again appointed to service, were not concerned. The probationer who is discharged from service for failure to pass the prescribed test or examination, re-employed pensioner, government servant, etc. But those things, these are the categories which they have been carved out.
What applies to you is number 2. Period of service in the work charge.
No, they are also work charge.
Okay.
They are dealt with in sub-rule 3. I'll go one by one. Sub-rule 3, your lordship may kindly now read. Notwithstanding anything contained in clauses 1 and 2 of sub-rule 2, your lordship was referring to this clause 2, sub-rule 2. Clause 2 of sub-rule 2, a person who is initially appointed by the government in a work-just establishment for a period of 5 years or more and is subsequently appointed to the same or another post in a temporary or substantive capacity in a pensionable establishment without interruption of duty, the period of service so rendered in work caste establishment shall qualify for pension under this rule. So it gave a protection, Mila.
In other words,
So this is overriding rule,
in other words,
Mila.
the non-obstante clause enacted in sub-rule 3
Right, Mila.
makes an exception to sub-rule 2 to
Clause 2. Lordship is absolutely correct. So the moment he is brought over to the pensionable establishment after rendering continuous period of 5 years of service, so that period of service which he rendered in the work caste establishment would be computed towards the qualifying period. Am I clear?
Yes.
So this distinction has been drawn in Sudhanshu Jena case.
Two conditions are 5-year service. He should have worked for a period of 5 years continuously.
My lord.
Then he should have been brought to an establishment which is otherwise pensionable.
Absolutely right. Your Lordship may now come to this another non-obstante clause which came to be inserted in 2001 amendment. Sub-rule 6. We are concerned with this.
Sub-rule 4 also you read it.
Sub-rule 4.
Contingency word is there.
Yes. Anything contained in sub-rule 1 by general or special order prescribed any class of service or post which were previously borne under the work caste establishment or paid from contingencies to be pensionable. But then again it is work caste, but this particular job contract, they have been dealt with in sub-rule 6. Your Lordship may kindly come to that. That is, following the direction of this court in the job contract employees association case. And the tribunal and the learned single judge, they have completely misplaced. Even this rule 18, sub-rule 6 of rule 18 has not been dealt with at all. So that is why the Honorable Apex Court said that Nityanand Biswal was wrongly decided. So the present judgment which is impugned before your Lordship,
Rule 6.
Rule 6. We are
Rule
concerned
6.
with this. That is the crux. Notwithstanding anything contained in clause 1 and 3 of sub-rule 2, let's 3 period of service paid from contingencies. Sub-rule 3, clause 1 and 3 of sub-rule 2, a person who is initially appointed in a job contract establishment and is subsequently brought over to a post created under regular pensionable establishment, so much of his job contract service period shall be added to the period of his qualifying service in regular establishment and would render him eligible for pension. Milord, your Lordship may kindly mark the distinction between the language employed in sub-rule 3 so far it concerns the work caste establishment, and sub-rule 6 so far it concerns relates to the job contract employment. They say that the entire service period would be computed for the purpose of pension. But here, Milord, the word is little different. They say that this so much of the period in the job contract establishment.
Only difference.
That's the difference.
Mr.
So they
Acharya.
say that the entire period would now be computed for the purpose of pension. Milord, they are
Acharya.
getting pension, the qualifying pension.
Mr. Acharya, you are placing sub-rule 3 in juxtaposition with sub-rule 6.
Absolutely correct.
In sub-rule 3,
Yes.
2 conditions. 5 years of service, 5 years of service, and being brought on an establishment which is otherwise pensionable.
Pensionable.
Here, such a restriction is not there. It
Absolutely.
only says if he is brought over to the post created under regular pension establishment.
Right.
Yes. Then the so much of service is there, na? What is meant by that?
Yes.
The question.
Milord, that is for the purpose of qualifying pension. Milord, there is a qualifying service for
So
minimum.
much of the job contract means.
Milord, the qualifying service for pension is 10 years.
Correct.
So suppose, Milord, somebody.
Can you take us to the rule where it says 10 years?
So anyway, we have seen that.
It's 10 years entitlement.
But just quote that rule. We have
That
to
is
because
not-
in the
that is not in dispute.
No,
I-
but
I am
wait,
suing.
Mr. Acharya, many things will not be in dispute at all.
That's correct.
Judges want to know because they have to structure.
No, I'm
the
suing
judgment.
it. I'm suing it.
Yes.
Just one.
Therefore, you have to tell the rule. At least when the court asks you.
Milord, I'm assisting. Milord, I'm assisting. Milord, your Lordship, this is, Milord, the period of his qualifying service in regular establishment and would render him eligible for, before that. So much of his, let's read from this.
So much of
his subcontract service period shall be added to the period of his qualifying service. Suppose he is brought
it
over
is 7 years and here it is 3 years, 5 years. It is not 5 years will be added, but only 3 years will be added to make it qualifying service is your contention.
That's correct. That is exactly what has been, decided in Sudan Sujana case. I will take your lordship to that judgment. A batch of cases, around 400 or 500 cases were challenged by the state in the Supreme Court. There were a delay, but still then, since it was a huge burden on the exchequer, while issuing notice, the delay was condoned and the Honorable Appeals Court went into the merit. There are conflicting judgments also, This court in Nityanand Biswal case, relying upon which the present judgment has also been passed. So also Sudan Sujana, which was carried in appeal to the Honorable Appeals Court. The decision now is Nityanand Biswal was wrongly decided, number one. Nityanand Biswal has not taken into account the effect of Sub-Rule 6 of Rule 18 and Judiciary of and 2-3 other judgments of this Honorable Court, they govern the field. That has been referred to your lordship would permit. I will take your lordship to that judgment little later. Here, factually, if your lordship would look at, those job contract employees were subsequently regularized. Some of them had only 3-4 years to retire, some 5 years to retire, because all of them were not appointed against any sanctioned post. Posts were not created, nor it was concurred by the Finance Department. They came to be appointed by various sources.
Mr. Acharya, we have understood that. We have understood crux of the matter. We are putting our case to you.
Right.
Kindly come to Sub-Rule 3.
Sub-Rule 3.
Yes. Sub-Rule 3.
Correct,
The terminology of Sub-Rule 3.
Right.
How it is. The expression so much is missing in Sub-Rule 3.
Absolutely.
That is stress of your argument.
Right.
Kindly come to,
admittedly are not in challenge.
Kindly come to the last but one line in Sub-Rule 3, if you are holding the same book.
Same book.
Yes. The period of service so rendered in work charged establishment shall qualify for pension under this rule.
Right.
This may be 5 years, 10 years, 15 years. Whatever.
Yes.
But when we keep the language of Sub-Rule 3
right
in juxtaposition of Sub-Rule 6,
yes,
now kindly come to his job contract service, so much of his job contract service period shall be added to the period of his qualifying service.
Qualifying service, your lordship may kindly mark. Qualifying service.
Correct.
But here it is qualify for pension.
In a regular establishment and would render him eligible for promotion. Let us take case of A now.
Right.
A was job contract holder for a period of 7 years.
Right.
And his regular service was also 7 years.
Right.
Arithmetically, that would come to 14 years.
Right.
The rule which we asked you and which you did not reply specifies 10 years as the qualifying service.
Rule 10.
You have not put it that rule to us because for structuring the judgment,
yes,
everything has to be stated. At least this is what Aaron Barak of Israeli Supreme Court Chief Justice says. How not to write a judgment, his famous book. Now, any one of you can assist the learned AG.
Madam, 1 second.
Which is the qualifying service?
Let me just, there is 10 years, my lord, that there is a scale, notwithstanding in
No, we take it as granted now. We will assume that it is 10 years because if learned AG says, every word will be treated with the due respect. Therefore, we believe you, it will be 10 years.
Let me, because that aspect 10 years is not.
Anyway, let them clarify. Generally, in most of the states, it is 10 years.
Yes, it is 10 years.
Also,
the maximum pension is 30 years. So, let
us assume that.
It is
now,
there.
Come to X case now. Mr. Acharya, let us clarify. We'll keep it aside now.
Right.
Whatever is the qualifying service. 7 years job contract service, and he is brought on to an establishment which is otherwise pensionable. That is another 7 years. 7 plus 7, we are taught it is 14
years.
Now, they say all 14 years should be treated for the purpose of computing the pension.
Right.
You say, if we do it, we will be doing disservice to 2 words in the rule, namely, so much of his people.
Absolutely correct.
That is your case. And one support base for you is, you are going to the language of sub-rule 3. Sub-rule 3 does not restrict it.
Right.
It puts a precondition, a condition precedent, 2 conditions precedent.
Right.
Number 1, he should have put in 5 years of work charge establishment service. Then he should have been brought on over to an establishment which is pensionable.
Right.
That absence of so much of in sub-rule 3, but its presence in sub-rule 6 makes all the difference is your contention. Although the quality of English language of so many of your rules are not that satisfactory.
Right.
I have seen many rules in the short period of my service here. Anyway, that we cannot say and send the clients back.
Right.
We have to draw milk from that language only.
Right.
So this is what you are saying.
Absolutely.
So your first contention is that a rule has to be interpreted in the light of peculiar language employed in it, in contradistinction to other rule.
True, Mina.
This is what you want. Otherwise, the rule loses the meaning is one thing.
True.
Number 2, it may be a heavy burden on the exchequer of the state is another.
Right.
It is not some partly some or some award, etc.
Thousands of systems.
That's what you are saying.
So, but Miller,
how Apex Court approached the matter?
Miller, that is correct. If your lordship would straightway come to that, that would be the end of the matter. Miller, let me just factually also, it is identical. The case which was relied upon by the Honorable High Court, by the learned single judge, in many cases, writ appeals were filed. And most of the writ appeals were dismissed on the ground of delay. Not a single writ appeal was dealt on. This is, I think, the first case which is coming after the Supreme Court judgment. It was decided on merit. Following one Surama Manjari's case, that delay and latches.
Which is that judgment? Sudhan. Let us see which paragraph.
How can this be? That will be the end of the 70 page.
Any coordinate bench decision on this point?
Yes, single judge bench contrary to this step party.
Not in the page.
Let it come tomorrow, Millard. I think he's not properly. Let it come tomorrow. I am also feeling disturbed by arguing in a piecemeal manner. Judgments, Millard, 3 copies should have been brought. Then I'm sorry.
We'll just look at we have begun. Half begun is best done. Let us see.
This judgment.
Generally, we are against installment arguments, whether it is on this side or that side. Yes.
Millard, your lordship, let me place this Sudhan Sujana first.
Please. Give that.
So that writ appeal is listed.
No, this is the writ appeal, Millard.
This itself.
This is of 2023.
Yes,
17
That is also posted today.
Today,
That's what.
It is in the board, It is in the board.
Millard, that is the matter which I am arguing now. Krishna Chandra.
Paragraph 15.
Malik. That is the lead matter, I think. Exactly. List. That is the list. List of the other one.
Paragraph 15 of this judgment we shall see now.
Krishna Chandra Malik. No, your lordship may read it before that.
Before that,
Yeah, because otherwise,
that reproduces the rule.
yes. Let me, it's a very short judgment, not much.
We'll read entire judgment.
Let me place it.
Yes.
Delay condoned leave granted. While issuing notice, this was observed because of the heavy burden on the exchequer. The state of Orissa has challenged the order of division bench of the Orissa High Court by which the writ appeals were dismissed due to inordinate delay in filing of writ appeals. Even this court had earlier dismissed a few special leave petitions on the same dispute. Some other cases were also dismissed. The judgments of the single judge which followed Nityanand Biswal case, many cases were also dismissed in limine. Your lordship may not, I may not, that Kuneha Mohammed and Kude Disciplinary, that principle of merger, doctrine of merger doesn't apply. They were dismissed in limine simply on the ground of delay, which were belatedly filed even before this court. All the same, we are now examining the cases on its merits, considering the importance of the matters. Nevertheless, the casual manner in which the state authorities, particularly the concerned department of the state and the land records office, survey office, etc., handle the matters is a matter of concern. That is why a heavy cost has also been imposed, 1.5 lakh for each petitioner. So that is not the outcome. It is not a case concerning a few employees. Rather, it affects a large number and in turn the state exchequer. It is for this reason that we were persuaded to look into these matters, although initially we were not inclined to interfere, considering the lethargic approach of the state in pursuing these matters and the inordinate delay caused, which was never explained in any satisfactory manner. The state, though, kept filing one special leave petition after another before this court, not in one go, but one after another, most of them belatedly to complete a mere formality. For this reason, many of these petitions have been dismissed on the ground of delay itself, as stated earlier, as courts do not come to rescue those who slip over their rights, be it the state. The liability of the state on this issue will be addressed towards the end. Now, since we are taking up these matters, what will be the fate of the already dismissed petitions? After our determination, we will address at the end. They said that you file review. In those cases, in the last concluding paragraph, in the state of Orissa, apart from regular employees who are working on sanctioned posts in various departments of the state, there are also a large number of employees who were working as job contractors, who are mainly engaged for purposes of survey and preparation of maps and for the purposes of consolidation of land holdings, etc. Their services were not pensionary services, and thus, even when they had put in long years of service as job contractors, their services were not counted for pensionary benefits and they were not given any pension post their retirement. The rules which were applicable in the state of Orissa at the relevant point of time with which we are concerned are known as Orissa Civil Services Pension Rules 1992, so and so rules 1992. Then a case came up before the division bench of Orissa High Court, that is Settlement Class 4 Job Contract Employees Union, Balasore versus State of Orissa and others, OGC number so and so, hereinafter Job Contract Employees Union case, which was decided on 24/3/1992. The High Court considered the non-payment of pension to job contractors as an unfair practice and even violative of Article 14 of the Constitution of India. Many of the job contractors were subsequently regularized in service, but in most cases, this
at the end of the service point.
Towards the end of the service, where these employees had not completed the mandatory period of pensionable service, which was 10 years. This is therefore,
look at 47.51. 47.51.
47.
5. Roman 1.
47. 10 years. Hence, the job contractors, though regularized in service before their retirement, were still not entitled for pension. The High Court in this said judgment said as under. This apart, this is Justice Hansaria's judgment, those job contract regularization, etc. So this apart for the purpose of calculating the pensionary benefit, so much of their earlier service period shall be reckoned, even if there had been breaks in their employment, so as to make them eligible for pension. That's it, got it. Here is this was the direction. So Nityanand Biswal, the court went a step ahead, especially the tribunal, and the Honorable Single Judge has been following the tribunal's order. I'm coming. It has been discussed.
But challenge whether tribunal also traveled to Apex Court.
Supreme Court. That has also been dealt with here. That has also been dealt in this judgment. So notwithstanding that they have come here, the necessity of giving this direction has been felt, because if service rendered after regularization alone shall be counted for pensionary benefit, most of the present incumbents would be denied the same, because to earn pension, 10 years minimum service is necessary, which most of the incumbents at hand would not put in after regularization, as they would retire before completing this period, having been appointed 2 decades back. So therefore, my lord, the essence of the Honorable Division Bench judgment was to make them eligible for minimum pension, to make the entire, suppose 3 years, for 3 years they were regularized, or 3 years remained till the retirement from the date of regularization. 7 years of the job contract period would be counted for the purpose of making them eligible to qualify them.
In other words, regardless of length of service. As a job contractor, what would be counted is to make them only the eligible service, the qualifying service alone. In other words, to make the qualifying service, the service rendered by them would be counted.
That is what the rule below. That's why.
That's how.
Yes.
But that could have been drafted that way.
No, that is the language, Milord. Your Lordship,
language is like that.
That is the Milord. Your Lordship knows while the executive makes a rule, your Lordship knows the.
In fact, I recently.
So that is
Mr. Acharya. Recently, I read one poem. I am the draftsman of all the laws, which will give rise to litigations having innumerable flaws. Something it read that way. It appears after reading your Orissa rules.
That is why your Lordships are here.
That poem.
That part of interpretation is entirely left to your Lordship's domain. That is why this judicial review. Otherwise, the state of Odisha subsequently published an office memorandum on 12 December 97, where it repeated what has been said by the High Court in its division bench judgment, while counting a part of the service of job contractors for grant of pension. According to Finance Department resolution number so-and-so, the 15th, dated 15th May 97, the job contract employees appointed prior to 12th April 93, after which there is a ban for engagement of such employees. There was ban, complete ban after 93. Under the administrative control of different departments, can be brought over to the post created under regular pension establishment after completion of 10 years service as job contract employees, subject to fulfillment of certain conditions and stipulations outlined therein. According to the provisions contained in the said office memorandum, the date of regularization shall be reckoned as the first appointment to the service for pension and other benefits. It has come to the notice of the government that some of the job contract employees are observed under the regular establishment almost towards the end of their service and become ineligible to get the pensionary benefit due to the length of regular government service in pensionable establishment. This has caused hardship to such type of employees. The Honorable High Court of Orissa, at the judgment which I just read out the relevant paragraph, directed that for the purpose of calculating the pensionary benefit, so much of their service period shall be reckoned, even Orissa Administrative Tribunal have also, in their judgment in way number, have categorically directed to count that so much period of job contract service of the employees, which will make them eligible for pensionary benefits. After careful consideration of the matter, the state government have been pleased to decide that for the purpose of pensionary benefits only, so much of their job contract service period shall be added to the period of qualifying service in regular establishment as would render them eligible for pension. addition of that portion of job contract service shall not be counted for calculation of gratuity. That is for the limited purpose of this, it's a welfare scheme. Thereafter, in the year 2001, an amendment was finally brought in the Odisha Pension Rules 92, wherein sub-rule 6 was added in Rule 18 of the said rules, which reads as on that. This particular rule which we were reading earlier, so that has been quoted here. Notwithstanding anything contained in clauses 1 and 3 of sub-rule 2, a person who is initially appointed in a job contract establishment and is subsequently brought over to the post created under regular pensionable establishment, so much of his job contract service period shall be added to the period of his this is clause, so much of the job contract, etc. The judgment of Odisha High Court, the subsequent circular of the government, and then the amended rules, all three gave pensionary benefit to employees who were job contractors earlier, but provided that only such period of their service of job contractors will be counted for pensionary benefit as was sufficient to entitle them for pension. The claim of job contractors for considering the entire period of their service for calculation of their pension was negated, and only limited years of service was to be counted in terms of the above, which would suffice for their entitlement for pension. These provisions were never challenged before any court. Neither 97 memorandum nor the amended rule inserted in sub-rule 6 of Rule 18, nothing was under challenge. They said that the entire period should be counted, clearly misinterpreting the division bench judgment of 93.
Is there any, Mr. Acharya, I have completed reading of the judgment line by line. We have completed reading of the judgment line by line.
Because I was reading slowly.
Yes. No, you are justified in that. We went little faster.
Right.
Sometimes you go faster, other times the bench goes faster.
But
together is the ideal route. Anyway, now 3 questions arise in this case.
Yes.
Beyond 3, there is nothing. Number 1, whether the quality and quantum nature of services of work charged people is or on par with that of job contractors. Apex kept it open. No, kept it open.
Yes.
Apex could say it. We have to consider it here.
That's correct.
Whether
But in the reach of the here, the scope is very limited. It's a latest patent topic.
Anyway,
Yes.
the court, when highest court of the country tells us,
Right.
we can't put forth any other argument.
Right.
Because they have said that in one paragraph. I will take you through now.
No, I have read the whole.
That is number 1. Number 2, one aspect which has been missed, maybe by inadvertence or otherwise, is whether regularization of the job contractors, was it normative or it was left to the sweet will of the government? Because one set of work charged employees in 1975, they worked till 1995, 20 years. Thereafter, you regularize their services under government rules, etc. Others are appointed in the same year. They are not regularized till 2000. They go to court and get regularized. Therefore, we want to know whether the scheme of regularization, be it executive or covered by the rules or legislative coverage, we do not know. I do not know. Whether the regularization scheme was there or not, or any scheme could emerge from reading various orders of the government, executive instructions of the government, resolutions of the government. In one case, Mr. Mohanty brought to our notice a 2008 resolution providing for that also.
Right.
Therefore, first one is the nature of services rendered by work charged employees and that of the job contractors. If both are same, then the question is whatever benefit you are giving to work charged people has to be given to these people only. That is how Apex Court has indicated in the judgment.
No, that is exactly, no, that argument was not, that is not the case. Let me read it. That is not, it is nobody's case.
That is no, therefore I am telling you.
That's correct.
You have joined hands or not.
Yes.
Apex court has indicated it. Kindly come to.
Before that, 3 more paragraphs would be relevant. Your Lordship may kindly, because why this incongruity has surfaced, Your Lordship may kindly, there are conflicting judgments of this court also.
Yes.
One thing is certain, that nobody has challenged the virus of that 1860.
Court has said that. Court has said in so many
That's correct. So here also the same scenario. That in this Frusikes case also, which is impugned before Your Lordship, they simply say that give them the benefit as per Nityanand Biswal case. So Nityanand Biswal case has been held by this judgment Sudhanshu Jaina not to be a correct law. Your Lordship may kindly come to this place.
We agree with
this ruling was followed when it ordered inclusion of the entire contract in calculation of pension in Nityanand Biswal. The state of Odisha, we will deal with this aspect later. Your Lordship may kindly come to this answer. Para 9. In the present batch of cases, the Lone single judge of the High Court relied upon the judgment of the tribunal in Nityanand Biswal and ordered that the entire service period be counted for calculation of pension of job contract employees. The writ appeals were filed belatedly by the state and were dismissed on the ground of laches. We are totally in agreement with the submissions made by Lone Senior Advocate so that the order of the Lone single judge cannot be sustained. Moreover, as stated at the outset, the division bench judgment dismissed in writ appeals of the state on the first day itself, undoubtedly on the grounds of delay. Had the division bench given them an opportunity, the state would have explained the entire legal position and expressed the anomaly in the order of the single judge. At this stage, we must put on record the distinction between work-caste employees and job contractors. Although this point was never argued before this court by any of the two parties, we must nevertheless, in all fairness, state the law as it stands today for work-caste employees as distinct from the job contractors. There are judgments of this court which have directed that the entire service of the work-caste employee has to be counted for pensionary benefits. That's also what the rule says. Sub-rule 3 of Rule 18 says, once such an employee is regularized in service, the reference here would primarily be to a 3-judge bench decision in Prem-Singh. So which has relied on 2 earlier decisions of this court and has held that once work-caste employees are regularized in service, their entire period of service in a work-caste establishment has to be counted for pensionary benefits. But then that was said by this court in context of service rules and regulations relating to Punjab, Uttarakhand and finally Uttar Pradesh in Prem-Singh. The rules though did not provide for pension to such employees. Although in a recent 2-judgment decision, this court in Uday Pratap Thakur and another, state of Bihar, SEC one so filed denying the benefit of entire period of service as work-caste employees to these employees for calculation of pension. This court had held that the ruling of the 3-judge bench is in an entirely different context and stated as under. In so far as the submission on behalf of the appellants that their entire services rendered as work-caste should be considered and are counted for the purpose of pay. Because we are not concerned with this work-caste, so let me skip this. Your Lordship may now kindly come to para 13. In our respectful opinion,
that logic may apply. I mean, the logic enunciated by the Honorable Supreme Court, if the same is accepted in that case, it would tantamount to regularizing their services from the initial appointment.
Right.
But para 13
does not appear to be, that is
Prem-Singh has to be bad.
That is correct, Milord. We are not on that. We are, so far our facts, our rules are concerned, we are on that. That has been very exhaustively dealt with. Para 14, be that as it may, we are still unable to grant the same relief to the respondents, means job contractors, as has been given to the work-caste employees by this court, and as indeed was their prayer before the High Court and also before this court. So, Milord, the respondents are job contractors. The reason being that in the Odisha pension rules, a clear distinction has been made between the work-caste establishment and the job contract establishment. In order to keep a proper perspective, perspective, we need to refer to Rule 18 of the above rules, which is as follows. The entire rule has been quoted.
And come to 15 now.
15. This 3 and 6 has been highlighted in bold letter, Your Worship.
No, we saw that. We have read it
Yes.
twice. Huh?
Yes.
If you want to again, we shall read.
As stated earlier, there is a clear distinction between the employees who are in work-trust establishment vis-a-vis those who are in job contract establishment. The distinction becomes obvious from a bare perusal of sub-rules 3 and 6 of Rule 18 of the Odisha Pension Rules, where it is given that work-trust employees who have worked in the establishment for a period of 5 years or more without interruption and are subsequently appointed to the same or another post in temporary or substantive capacity in a pensionable establishment, the period of service rendered by him or her in a work-trust establishment shall qualify for pension under the pension rules. Compare this with the provision relating to job contract establishment for whom it has been specifically stated that in case of a job contract employee, after he or she is brought in pensionable establishment, this is important, Miller, last 3 lines, only that much period as job contract service shall be added to regular service as would make him qualified or eligible for pensionary benefits. Again, as we have already stated in the preceding paragraphs, these Odisha Pension Rules 92 or the distinction under the law have not been challenged for any court, nor in the present case also, Miller. The same case, Miller, we were, it is the establishment. Anyhow, as we have already stated, this was also the point which was never mentioned before this court. Leave aside any argument being made by any of the parties in this regard. We are therefore at a loss to examine as to whether the work the two are actually performing is similar or not. Therefore, we are not in a position to determine whether the classification itself between the workers and the job contract establishment is artificial or an unequal classification to make it violative of the Article 14 of the Constitution. There is no challenge also. Now, suppose in an appropriate case, it may be challenged. That is not in the present case,
No,
admittedly. They say follow Nityanand and grant them.
In other words, what you say is, you are structuring your argument on these inarticulate premises. Number one, work charged employees constitute one class and the job contractors constitute another. That is how separate rules have been made.
That's good.
And they are two different classes. Number two, challenge to these rules on the basis of discrimination is not laid before this.
Absolutely correct.
Therefore, take the rules literally as they are.
Right.
As because of R.K. Dalmia,
Right.
the rules also enjoy a measure of presumptive value.
Right.
And therefore interpret them as they are.
As they are.
That's your case.
That's correct. So, therefore, although we may, however, mention at this stage what says so and so.
The amendment to sub-rule 6 is added on which date?
In 2001, Milan. This was never considered by any of the judgments. Neither Nityanand Biswal.
So this rule came subsequently.
No, it was earlier. It was existing.
But it was never considered.
2001.
2001.
Nityanand Biswal, I think, in 2004.
But that did not refer to this rule at all.
No.
So do you have a copy of
this Shripad has referred. The High Court, Honorable High Court, in 3 judgments, Your Lordship may kindly look at the Honorable Single Judge, Justice Mishra's judgment.
So, subsequent to, that was before the tribunal.
Yes.
It was before the tribunal.
No, before this Honorable Court.
But it is OA number is there, na?
Nityanand has been transferred.
Nityanand is a Milad way. Nityanand is a Odisha administrative tribunal judgment.
Decided of.
That is in 2004, I think. Nityanand
could be because it is of 2003.
Filing it is. Obviously, it would be.
Yes, that is in 14/1/2004. Nityanand Biswal. This judgment, Milad, is being followed as a gospel even by the High Court and say that you grant benefit as per this Nityanand. And the Supreme Court clearly says that Nityanand neither took note of the 2001 amendment nor even properly appreciated the division bench judgment of this High Court in job contract employee union case. There are 3 judgments of this court. taking a contrary view. This is the recent one.
Now we have understood your case. What is your first proposition? Just write down. We will write it down. I will write it.
Number one.
Make your proposition.
Yes.
Please write down.
Number one. Let the identical issue raised in this appeal, present batch of appeals, are akin to the factual background and the law, which came to be decided in Sudhanshu Jena, a recent judgment of the Honorable Sudhanshu Shekhar Jena.
The cases of the employees squarely are covered in the ratio of Sudhanshu Jena.
Shekhar Jena.
Sudhanshu Shekhar Jena. Kindly give the citation.
Yes, Milord, this must have been a civil appeal by now because leave has been granted. SLP number, Your Lordship may write down I will give Your Lordship the CN.
2025 INS
2146 of 2026 and other batch of cases. Milord, around 450 SLPs were decided together.
Very well.
450.
Maybe more than that. I was there. 476. All those cases were allowed.
This is what we have been reading.
SLPs by the state were allowed.
This is the sorry.
Number one. Number two, we will articulate on your own submission.
Milord,
there is a textual difference between
Rule 3,
Sub-Rule 3 of Rule 18.
Sub-Rule 3 and Sub-Rule 6
of Rule 18.
Of Rule 18 of Odisha Pension Rules 1992.
And no challenge is laid to these rules.
Right.
And therefore, literal interpretation should be adopted.
Right.
Number 2 is rule. Number 3.
Though the rules came to be amended in 2001, while deciding Nityanand Biswal case, the tribunal in 2004
did not much adhere to the amendment to Rule 18, which introduced Sub-Rule 6. Way back in 2001,
from 1st September 2001,
with effect from 1/9/2001, although the case was decided in 2000
on 14/1/2004.
On 14/1/2004, and therefore that decision is sub silentio.
Right, absolutely. So number 3, Milord.
Yes.
Number 3. This Nityanand Biswal case also has been dealt with in Sudhanshu Shekhar Jena.
They said it is not good law.
It is not good law.
Apex Court itself in Sudhanshu Jena has adversely commented upon the correctness of Nityananda.
Nityananda. No, there are two Nityanands. One is Nityanand Das, one is Nityananda Biswal. Nityanand Das, Milord, says that the service would not be counted. That is, that judgment I did not do.
That helps you. That also did not consider the rule at all.
Nityanand, State of Orissa versus Nityanand Das. WPs upheld the view of the state and dismissed the others as similar claims. There are 3.
Brother Shashikant Mishra's judgment.
No, that is judicial party. There are 4. Yes.
No, you said one is Nityananda simply.
Tribunal, the very same tribunal has also taken a contrary view. The very same in a subsequent bench. The very same tribunal has also, Milord, that is Your Lordship may kindly come to.
Contrary view in the sense they say that
Bhagavan Patnaik.
Qualifying period is to be
counted. Yes.
The addition is to only to the qualifying service.
No, yes.
Ultimately,
that is that.
Ultimately, the whole gamut of the case is left over for being decided by us.
Right.
We should not be guided by whatever decisions have been rendered. All they have been now because of the
this judgment will prevail, Milord. Because these are all single bench judgments on merit. So there are 2 views. Nityanand Biswal is not a view of the High Court. Some of the judgments which have been challenged before Your Lordship now in latest patent appeal and some were carried to Supreme Court. They were relying upon Nityanand Biswal. Many of them were dismissed on the ground of delay, which the Honorable Supreme Court said you file review. Your Lordship may kindly look at the last paragraph.
Review delay in filed. We read that. Whether any review was.
Yes, we have filed, Milord. Yeah, very few, I think 17, 18 cases were, or in majority of the cases, delay was condoned and leave was granted. So therefore,
They are before which
Justice Dulia. I was also arguing before
After
vacation
that,
a batch
review.
of matters again.
their review. What happened to review?
Review, Milord, has been filed. It has not come. That will, Milord, the same. It will come before the same bench, and the court has directed to file the review only for this limited purpose of delay. So now they have examined it on merit. None of the cases were gone on to merit.
Those cases are pending here only.
Before you are
Supreme Court.
in Supreme Court, some of the SLPs were dismissed.
There we are filing review.
So that is not, Milord,
Relevant for much relevant.
So now, Milord, this Frusi case judgment and other cases, they are also in the same language. Nityanand Biswal, you would follow Nityanand, you grant them benefit. The judgment in Sudhanshu Sekhar Jena also, Milord, Justice. So the same judgment. Follow Nityanand and grant them benefit. So this is also the impugned judgment. Should I read it, Milord? In the present appeal, the same judgment.
The same judgment.
What I heard from His Lordship is that any judgment that discussed on merit, according to you, any judgment of
We
High Court,
considered sub-rule 6.
Sub-rule 6 Judicial party, Milord. The judgment which I just now heard. It's a very well discussed judgment. Justice
Brother Shashikant Mishra's judgment.
It's a very well discussed judgment.
Can we
This
read
is
the judgment after eating our lunch?
Yes, Milord. No, sir. I'll come.
Yes.
I'm sorry, Milord.
Yeah.
That item 43, that withdrawal matter, Milord.
Yeah.
Government.
He wants to withdraw the no objection.
No matter. Let them withdraw.
because you have taken a specific stand in your counter. You must understand. So after notice matter, still you have no objection. You are conscious of this.
Learned counsel for the instruction.
Item, Mr. Mahanti, what serial number?
43. Learned counsel appearing for the petitioner seeks leave of the court to withdraw the petition. After seeing the statement of objections filed by the answering respondents. First, the respondents consents unconditionally to the grant of leave. First up. Next paragraph. In view of the above, petition is dismissed as withdrawn.
I may pardon, Millard. Item number 33. I was appellant. 33. On the first hour, in my absence, the opposite party prayed for an adjournment.
That's a complaint against the bar, not against the bench at all.
In my absence, he prayed for an adjournment.
Then how?
I am the appellant.
Unless you pass a resolution in your bar saying that no court shall grant adjournment without having the opposite party in the presence. We'll do that.
And our standing question, not standing order, standing question to the request that please inform.
Inform the others.
In after notice matters, so that, and even Lordship has observed that whenever the other...
Only my humble prayer is, my Lord.
Date, what is the date?
It has been, your Lordship has granted time to 11th August.
Second week of August.
My submission for Lordship is that I am a terminated FI. Though person who was appointed in my post.
We are in the halfway through in a very important matter wherein our learned AG is appearing. Generally, we should not interdict such arguments. Therefore, it will come. But
Why only pray for
one thing, sir. You are doing the same thing mentioning in his absence. So you file a memo, take his consent and
Yes.
Then I just pray for in the month of July.
Sir, you are
The
praying
month
the
of
correct, sir. You are
July, in the month of July.
But our calendar is full. Our calendar is full. Otherwise, we are always here. Even if Cobra comes in at our feet, we cannot run away. Let us see. Let us see. Okay. Yes. Yes, lovely G.
Before I come to the other judgment, may I please draw your Lordship's attention to the judgment in Sudhanshu Sekhar Jena, which came to Vijay.
With your permission, wherever we have directed personal appearance of matrimonial parties, 22, just because they have to travel back long distances sometimes. Sometimes there will be women also. 22. The parties have to travel back to their places, no?
These are all sensitive matters, my lord.
Yes.
That you get. So, my lord, before I come to Judestir, let me place the impugned judgment in the first lead case, Krishna Chandra Malik. That is WA number 17 of 2023.
Arising out number?
Arising out of WP OSC number 2730 of 2017.
Yes.
It a press admission.
Open that one.
Orders.
I
don't know 10. Yes. The lead matter, the first
It's
one.
not a place to learn things. Please come this way. It doesn't know anything.
It could be disturbed again.
But you are taking of the impugned judgment in written.
Yes, Milord. Because why I am showing this judgment, Milord, this same judgment, Milord, just stereotype in Sudhanshu Jena. Your Lordship may kindly the 2-page order. All those orders were not identical orders.
Page 20 of the brief.
Page 18.
18 of writ appeal.
Of the writ appeal.
They refer to this
Nityanand Biswal.
lead judgment is referred and they have passed these.
Nityanand Biswal, Milord, is a way order, in fact, tribunal order. So they have said that they follow this tribunal order and grant relief to everyone because that came to High Court in a writ. Writ was dismissed. State appeal went to Supreme Court. That was dismissed in limine, but which was again, Milord, discussed in Sudhanshu Jena, present one. This
Biswal.
Nityanand
Biswal. The writ petition.
Right.
So that was decided on merit or so that was also dismissed on ground of delay.
Delay, Milord.
That my lord has been asking you.
That's correct. Delay.
So Nityanand Biswal writ petition?
Nityanand Biswal is a way, Milord.
Correct, sir. The appeal to the Nityanand Biswal, WPC 14244 of 2006.
6.
Come on to the High Court website.
No, it is there, Milord. I'm passing on. I'm passing on the judgment.
The 14244 of
The one copy I have given.
So different ଗୋଟେ କପି ଦେଇଛି ଗୋଟେ
ଦେଖେ ତମେ ଦେଇ ଦଉଛ ମୁଁ ପୁଣି ପଢିବି।
Computation देखो
फाइनल
WPC No, sir. It's not Nityanand Vishwa.
Yes, it is right.
The rate petition,
This means you apex for.
14244.
Yes, ma'am.
14244.
The tribunal's order was under challenge. That was disposed of on 9440.
This, in other words, in all other matters, the orders are paternalistic.
Right.
By pattern they went. That's what.
Same thing. They say that Nityanand Vishwa directed that entire period is to be counted.
Look at this. Nityanand Vishwa is against this. They all made it. It's not to do it. Indian bench. When he said in Nityanand Vishwa, the minister said it's required. It's not.
Your submission that whatever matters have already been decided,
Right.
we should not take them as laying down the ratio.
Right.
And we should decide it afresh because matter has been sent back to us
Right.
with a direction to treat it on merits.
Right.
That's your case.
Right.
So because there are judgments on both the spectrums,
Right.
this side and that side.
Right. Right.
And if the court relies on Nityanand Vishwa, and look at Nityanand Vishwa.
It does not, it only says qualifying service.
Look at Nityanand Vishwa. You are having this topic.
Nityanand. Right.
That may be in his favor only.
We were
Following the
putting,
judgment
order
of
number
the
9,
apex court and the state.
Order number 994/2014, disposing of Nityanand Vishwa.
14/1/2014.
9th of April 2014.
Mine. That is a High Court's judgment.
Yes,
Correct.
High Court judgment by the division bench.
Right.
Look at the challenge, the second paragraph.
Passed by the learned friend, the direction was made to take into consideration the period of engagement of the petitioner under job contract establishment while calculating qualifying service.
Read slowly.
When calculating
Right.
qualifying service.
Right. And accordingly, his pension and other pension were due and admissible was directed to be revised and paid after adjusting the amount if already paid. Lord has already relied upon. Yes, my lord. This.
So the argument that Nityanand Vishwa says it has to the entire service may not be correct also. But the problem is SLP civil number 13916.
Against the same is negatived.
That is the earlier one.
Earlier one.
Earlier one
You have
was
copy of
dismissed.
that? 13916.
One, yes, that is there, my lord. They said dismissed both on ground of delay and merits.
When they're referring to 211094 is Justice Ansariya judgment.
No, my lord. No.
94 judgment.
A one-line order, my lord. At the stage of admission, this was dismissed in limine.
High Court judgment in OJC 2405 of 1985.
My Lord Justice
Yeah,
Ansariya.
it is there, my lord, with us.
Sorry, yes.
So that is different.
OJC 2405 of 1985, my lord. It is there. ଗୋଟେ କପି କରୁଛ କେମିତି ହବ ଆଉ ନାଇଁ ଆଗରୁ ଦେଇଥିଲ କିନ୍ତୁ ଆସିବ ଆଉ ଆଉଥରେ ଆଣିଥାନ୍ତ ଗୋଟେ ବଞ୍ଚ করে ମିଳଟ ଓନ୍ଲି ସରି ଗୋଟେ କପି ଦିଆଯାଏନି ମିଳିବ ମାନେ ଏତେ ପୁରୁଣା ମିଳିବ କୋଉଠି ଜେରକ୍ସ
I have seen that. We have seen that.
yes Lord, here also that was not say. This is a clear misinterpretation. They say, my lord, they have quoted the Supreme Court para 13, my lord. Para 13. Be entitled to this apart for the purpose of calculating the pensionary benefit. So much of their earlier service period shall be reckoned.
That's what.
Even if there had been breaks in their employment, so as to make them eligible for pension.
In other words,
Yes.
it is only eligibility aspect in the sense.
Right.
Qualifying service is the focal point of sub-rule 6.
Right.
And not addition of service to qualifying service.
Yes.
In other words, whatever service the this contract serviceman will put in, only that portion which should make qualifying service complete alone will be reckoned. The rest of the things will go to
the next page. Also, the next page, the division principles. Regularization alone shall be counted for pensionary benefit. Most of the present incumbents would be denied the same because to earn pension, 10 years minimum service is necessary, which most of the incumbents at hand would not put in after regularization, as they would retire before completing this period, having been appointed 2 decades back. At this stage, it would also be pertinent to point out that most of the incumbents had been employed so and so, though this government, before parting with, held at the post of the process server. Before parting, would say that on improvement of the financial position, it would be open to the petitioner to approach this court seeking modification of this period of other benefits available.
Now, that is my question. Mr. H.G., one more question arises because the apex court in Bhupendranath Hazarika's case said the state has to conduct itself as a model employer. Now we are, in the light of that, we are asking this question. Suppose one set of employees have put in 5-6 years of service and you have regularized. And they will get the pension because requirement of qualifying service is complied with, satisfied. One other set of employees, they have put in 12 years of service and their service, if not counted, then they will not get pension at all. And in one set, you regularize their services within 5 years. In other set, you take 25 years. That injustice, how we should treat in the light of legal position, rule position.
No, that's correct, Peter. That is not the scenario here.
And some may retire without getting qualifying service at all, even if they have served the state for 30 long years.
No, but at least that may be answered in an appropriate case. But here, Milord,
how many years all these people have?
No, all those cases are against the same stereotype order. But here, the question is very limited. Question is whether on the teeth of this Sudhanshu Jena's case, the judgment of the Honorable Single Judge is to be upheld or set aside.
Sir, your answer is that everyone is getting pension?
Everyone is getting pension, Miller.
Only thing is quantum will be less.
That's correct. Pension, they are getting pension, Miller. Whole period of service would be counted with
what would be the financial implication?
Miller, it would be huge.
How? Huge means maybe a very dangerous word in English.
Miller, in crores. I do not know what is the exact amount. There are many such, more than 20,000-30,000 employees. Miller, it would be in crores, 1,000, 2,000 crore. It is not. Otherwise, Miller, the state, I would have advised to implement. In many of the cases, I have this rehabilitation. 3,000 cases, Miller, we implemented. In Supreme Court, I gave the undertaking that I am going to amend the rules.
Some cases have been...
RSCP also, Miller, around 3,000 cases, both in High Court and Supreme Court will be put to an end. This compassionate appointment.
What is the amount of minimum pension they are getting?
10 years, Miller, whatever. I don't know.
What that amount? Whether it will be sufficient?
10,000, 10,000, Miller. 10,000, some around 10,000. No, that is subject to TI also. Pension they are getting.
How much amount they are getting as pension? Minimum pension?
10,000, 9,000, some odd 10,000.
Basic pension plus timely increments.
etc.
Can you not take the example? My lord is asking to take up an example, maybe this particular matter. You ask your officer.
How much is, or who is representing the concerned employee?
The respondent can answer that, how much he is getting.
The pleadings on both the sides are frugal.
No, they do not allege or assert anything actually. Suppose they say.
I say, they say we are covered by Nityanand grant.
They don't say that we are getting 10,000, we are entitled for 15,000. So let us get 15,000. That's the problem. We do not, they do not know that actually. Nityananda gives them Ananda.
Getting qualified.
The court wanted to know.
That your worship is right, but that data I don't have.
We may not, every argument need not be confined to the skirt.
No, your worship is absolute.
Frill is also necessary.
Right.
That way we are asking the question.
No, that I have
to
take
stitch a frock with the frill now.
No, that's correct. That
for that reason we are asking this.
I have to take instruction because I do not know what is
Anybody,
the
what your client, what did you say? We are paying for the employee, na?
Yes, my lord.
Yes, what is the amount you are getting as pension?
Well, sir, pension, my lord, already fixed, my lord, at the rate of 3,500.
That is way back in 2012. At the time of retirement.
Basic pension. Basic pension. The DA is what is the DA percentage?
It is about 60-70%. So now many people have crossed whatever their salary by pension.
Right.
By the fixation of subsequent.
Now we are getting 8,000 something.
Must be 10,000.
So somebody retiring at his post,
My lord.
suppose. So many are retiring at his post. Because so they must be getting some increment, so they are not getting more also. Or they are getting more.
But he's getting a
He would be getting the same bill.
That is
No bleeding set. Bleedings are as frugal as can be in any matter, matrimonial matter, service matter. They are not satisfying. That is, in terms of law and language, both they are lacking. Very sorry to say this. I am speaking the truth. I cannot hide it quite long.
Justice suddenly. Justice The judgments are also identical in same order.
Can't you ask your deputy to ascertain it from one of your secretaries? In minutes, it can be. In a couple of seconds, you can get that information. What is the pension? One phone call will tell
No,
us.
that I can ascertain, but
Just
this
tell us.
particular
So that we can- No, generally, minimum pension payable, once it is a qualifying period, is satisfied. What is the pension number?
the drawing and the review, the drawing and pension disbursing authority of this.
they get it from the different treasuries. It is
Minimum.
One particular this.
In one sample case, what is the minimum that is payable? Just we want to know because of Reptacos case. Look at AG. Mr. Acharya,
My lord.
we are telling this not for anything we are trying from the sky. This we are saying because of the apex court decision in Reptacos.
Right.
Otherwise, we would not have said it at all. Just we want to know what is the minimum pension that employee of
That
this class.
can be ascertained. That will
In a
take
couple
care.
of seconds, it can be.
The respondent is a retired peon in Tehsil office, Jagatsinghpur.
My lord, we can ascertain from the collector.
Collector of the Tehsil, what is his amount? His
Yes.
Of the Tehsil.
We can ascertain. I can inform you, lord.
8,300. Google, set the Google difference.
Google is at times misleading.
Google reads.
We can ascertain. It's not a big deal, my lord. I
In
can
the course of
I'll call the collector just now and ask.
we have understood now. Any other point proposition you want to put forth?
So this is the,
These
my
are
lord,
the- of course.
the apex court after deciding, my lord, nothing remains. The same order. In Sudhanshu Jena also, this Krishna Malik. Krishna Malik, my lord, order and Sudhanshu Jena, which was impugned in apex court, the same order. Paragraph sentence wise also, I think, copy paste.
Yes, who appears for the Other side.
My lord, I am appearing for this.
Yes, pardon. Just see the language of sub-rule 3 and sub-rule 6. How are you going to weigh them in the same balance? What you are saying is, you give us the benefit of sub-rule 3 of 18.
My lord.
They are saying they have to travel to sub-rule 6, not 3. Your platform is elsewhere. That is the gist of their submission. How do you justify? Language and you have not put the rules in challenge now.
In Rule 18.3, the period of service paid from continuous leases. And second, my lord,
Let us see slowly. We are reading, we have to go by halt and proceed principle.
Rule 18, conditions subject to which service qualifies. Service does not qualify for pension unless it is rendered in a pensionable
establishment post. 1 second. Wait now. Here is another hitch now. When you were working as job contract service provider, you were not in pensionable establishment. Agree?
No, my lord.
You were in pensionable?
Yes, my lord.
Then why is that question?
Because, my lord.
Where were you working?
My lord. Your lordship, you can see Rule 12, my lord. Condition of qualifying pension, my lord.
Rule 12.
12 is against you. 11 and
No. 10, my lord. Rule 10, my lord. Rule 10. Commencement of qualifying service.
Subject to the provisions
of these rules, qualifying service of a government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity.
Yours is not these three. Yours is a contract employment.
Yes, my lord. I will give answer, my lord, to that. Provided that, except for compensation gratuity, a government servant service does not qualify for pension till he has completed 18 years of age.
That is contractual capacity.
Then, Rule 11 then. Come to Rule 11. Condition of qualifying service. Subject to the provisions hereinafter contained, the service of a government servant shall qualify for pension if it conforms to the following 3 conditions. Well, first, my lord, the service must be under government. Then, my lord, second, the employees must be in a pensionable establishment post. And 3, the service must be paid by government. My lord, out of 3, my lord, the conditions, my lord, he is a job contract employee, my lord. But only post is a job contract, but he is getting all the facilities at par with the government employees. Because, my lord, the job contract, the petitioner, my lord, he is getting salary, my lord. Not any wages, my lord. He is getting salary and also dearness allowance, my lord. Only except increment, my lord. And except increment, he is getting grade pay, my lord. And there is promotional facilities, my lord.
No. Rule 10, Rule 10. 10.1. Read 10.1.
Rule 10.
It is subject to the provisions of these rules, means if there is some other rule which says something else, like Rule 18, that will prevail. In other words, these rules are subject to, in the sense, subservient to other contrary rules. Subject to is interpreted by the apex court in a half a dozen judgments. What is meant by subject to? What is meant by notwithstanding? And Rule 18 begins, notwithstanding anything contained in it. That's the concern of rule.
Exactly. But taking into account the Rule 11, my lord, now there is a provision, my lord, if he is getting certain benefits from the government, my lord, and also some period of service, my lord, has been declared as qualifying service. So why the entire period of service shall not be qualified? My lord, job contract period of service under Rule 18, my lord, the provision, my lord, 18.6, my lord, already some period of service under job contract service, my lord, has been counted towards qualifying service for the purpose of pension, my lord. Now, as per Rule 18, my lord.
Correct.
Well,
Some is true.
yes, my lord. If
Not
some-
entire service.
No, my lord. If some period of service is qualifying service, my lord. Because taking into consideration the Rule 11, my lord. 10, Rule 11, my lord. Because he is paid by the government and also get pay revision at par with the government employee from time to time, my lord. And also getting promotional benefits to higher post, even to inspector to serious that likewise. There is a promotional facilities also, my lord. And they are worked under the government, my lord. So since they are working under the government and paid from contingencies and service is paid continuously, my lord.
Paid from which fund?
Contingency, my lord.
Where you are reading that?
My lord.
Where from you bring it?
Yes, my lord. Rule 8, my lord. Rule 18, my lord.
I'm sorry, Mr. Das. Sir, is it your case that he retired as a Amin and getting pension as minimum pension or getting pension as Amin? That is not your case. The problem, you should confine, don't give a generalized comment on in a service matter.
No, my lord.
Please appreciate.
No, my lord. It is.
So, what no, I will not speak to you or
My lord.
can I speak to you?
Yes, my lord.
So, is it your case that Krishna Chandra Malik retired as a Amin, getting pension as a Group D employee, or because you are saying he has got promotion or he gets promotion, because that's not an answer to the query. Somebody retiring as a Amin will get pension as a Amin. Somebody retiring as a chairman will get as a chairman. Somebody retiring still higher, suppose regularized, still higher as a assistant ARI. He may not be RI, but assistant ARI.
He was JC chairman, my lord.
So job contract so please confine to that.
That's one thing. Now, if we accept your contention, to whom sub-rule 6th of 18 will apply?
Well,
To nobody.
Rule 18, my lord. Condition of service to whom service
Rule
qualifies.
18(4)(6). If we accept your contention, that amounts to virtually striking down the death knell of that rule.
My lord, Rule 18(6), my lord, they have confined only some period of service. So much of period of service.
To whom you are applying it? If you are bringing your kids at 10 and 11, then you will not travel to 18 at all. In no case you will travel to 18(6).
Because that is but a continuous, my lord. Because he has already in the rule, there is a provision. If the service is continuous and regularized without any break, interruption, my lord, that period of service can be counted, my lord.
Do you realize that you have taken benefit of 18(3), that proviso? Have you not taken the benefit of that proviso which grants you the benefit of adding of qualifying service? Have you not taken benefit or not? You have not taken that benefit.
I have taken that benefit, my lord.
So that is the question actually. What benefit, my lord? So that even after you have the period is added, you have taken the benefit. Now suppose you are entitled for full pension at the level of a promotional post. That's one way. That's another completely different aspect of it.
The counsel representing the employee submits that in the scheme of rules 10 and 11, persons working in job contract service would be entitled to pension, counting their entire service as such, and pension being not being a bounty in the light of D.S. Nakara versus Union of India, the submission of the DG should not be accepted. All right. Next point.
Next point, my lord. Your lordship pointed out that either similar matter has been decided by the division bench on merit or not, my lord. To that effect, my lord, my answer is similar matter came before the tribunal, my lord. Tribunal, my lord, dismissed the case.
That we know that.
But then that was challenged before the
ultimately,
and High Court on merit, my lord, decided the matter.
You will argue for us to understand. Therefore, to make it easy, we are telling what we have understood now. There are judgments on both the spectra, this side and that side. Ultimately, matter landed in the Supreme Court. Supreme Court said, you decide this afresh. Correct. Therefore, learned AG is saying, do not worry about all those judgments. All they pale into insignificance because of the order of the apex court. You follow the apex court's order. Decide this matter, being uninfluenced by decisions which are on either side of the spectrum. There are judgments which you said, we know that. And he has put those judgments across the bar. He has put the judgments.
In this second, my lord, point, my lord, the petitioner has already rendered, my lord, more than 35 years of service, my lord.
35 years.
35 years service, my lord.
When they were brought over to the post, regular post?
In 2012, my lord.
When they got entry to the service? In
78,
what is that, 7-8? It's not academic year. You have to give the year, only 1 year entry it will be.
Be specific in your submission.
I'll say that.
An academic.
24/1/1978.
He entered service on?
24/11/1978.
Krishnachandra Malik.
Again.
1978. And he was brought on the regular
14/5/2012.
Now, he retired on
31/5/2012. 16 days.
What is the pension he is drawing now? Pension is available? In your records also not available.
Exactly, it is around 9,000 some odd.
How he was brought on the regular service? Onto regular service? Any court order or
there was a scheme, my lord. Yes.
There was a scheme, my lord.
Under scheme.
Under scheme, my lord. And the scheme.
One question we want to ask you. 78, 88, 98, 2008. No, sorry. 88, 98, 2008, 30 plus 4 years. After 34 years, you regularized these services. Have you regularized the services of anyone who were appointed?
No, my lord. All of them were regularized in a batch.
My lord, one Pitwas also regularized, my lord, in 1990, my lord.
In
1990, my lord.
No.
And I'm collecting that.
2012.
One Pitwas Mishra, my lord, another person, my lord, similarly situated, my lord. JC employee. He was regularized in the year 1990.
That question will now.
Other persons means also regularized in the year 2000, my lord.
So therefore, where have you taken up those
my lord? What happened, my lord? The scheme was prepared, my lord, on 16/7/96, my lord. Pursuant to the direction of this court, my lord, and then also Honorable Supreme Court, my lord.
That scheme, does it contemplate?
Yes, my lord. That scheme. So, my lord.
One second, wait. Answer question.
My lord.
Question first. Then you can answer.
My lord.
I'm sorry, you are Mr. Das.
Mahapatra.
Mr. Mahapatra, sorry. That direction by the Supreme Court or the scheme, does it contemplate anything which could have made you regular before the date?
Before 96, within 3 months, my lord. Direction was specific direction was issued.
Which is what I told
my
you.
lord.
Can you repeat the question I told you? Yes, please repeat for me to answer.
Understand our own question.
My lord,
our question is,
my lord,
whether the scheme itself says any particular date with effect from which they will be treated as having been brought on the regular service.
2000, my lord.
Which is that date?
That scheme, my lord, already clearly stated, my lord, by the end of 2000, all such employees will be regularized. And that scheme was prepared pursuant to direction of the Honorable Supreme Court in Civil Appeal number 40. My lord, my lord, in Civil Appeal number 407 of 93. Then there,
but where from we should go and bring it? If you give entire material, we can look into.
My lord.
The judge need not go to the places wherever you need. Where are the pleadings? Where are the evidentiary material?
No, these are all those questions, my lord. I'm sorry, with great respect. These are not the questions in a latest patent appeal.
Not even the writ petition. There you are right. But
those pleadings were not there. Certain things, my lord, I think we're traveling beyond it. Because you see,
maybe the other difficulty could be that can we go beyond the Supreme Court judgment in
Sudhanshu Jena is the latest one, my lord. The recent view is Sudhanshu Jena, which directly dealt with the judgment of same word, same thing, everything. So the question is whether Nityanand Biswal ratio would be applicable to compute the entire period of the contractual service.
No,
the section
like
or the rule 18.6 would govern.
No, it's not
that is limited. Neither 18.6 is under challenge.
Not that.
Nor will the Article 14 violation has been alleged.
Not that simple, because the right to pension being part of the fundamental right of an employee, now we want to know whether you were very discriminatory in the matter of regularizing the services of these people. For those whom you want, whom you love, for them regularizing the services at the earliest point of time, and whom you do not like, maybe because of X, Y, Z factors.
Your Lordship is correct.
The regularization.
No, those questions would have been answered. Your Lordship, I don't disagree. This is nothing that pertains to me. It's a government policy. But question is that those questions could have been answered. Otherwise, I also yes, provided. Where is that? Where is the scope in a writ appeal? In an appropriate case, when he alleges discrimination, when he alleges that Article 14 is violated or 16 is, in that event, your Lordship may have an occasion to test the scope of that. But here the limited issue is the validity or the legality of an impugned order by a honorable single judge, which follows Nityanand Biswal, says that you compute the whole period, which Supreme Court says no.
All right. Any other point you want to say?
And my second contention is that the Honorable Supreme Court,
you said
on basis of the petition filed by the minor.
Give dictation to our client, our states now. Yes, take down dictation. Articulate your contention to the in justification of your stand. Yes, write down slowly. Articulate your point.
Don't hesitate. It is something, don't.
So that we can put the things in focus. Otherwise, you will go on and tangentially arguing. He also will go on arguing. Therefore, articulate the points so that we judges will treat those points. And give dictation now. Slowly, you can give dictation. Even if there are mistakes, nothing will happen. Certainly, the tempest will not come. You can dictate. And kindly take dictation. Or I will take your dictation. Just give us.
I have already stated, my lord, that point, my lord.
No, please. You articulate.
The
last point is
you tell him Odissi itself. So that we will write.
Upon the difficult, upon the difficulty in language. Then please calculate the second point.
First point you said, what is that? In the scheme of 1011, rules 1011, if you are employed against a post and you are getting the full salary from the government, then you are entitled to pension. Is it not? That is the point you have made it. We have made the first point.
Right.
Now let us travel to the second point, which is in your favor. What is that second point?
As per the order of the Honorable High Court and the Honorable Supreme Court, the petitioner should have been regularized by the end of 2000, my lord.
Where have you stated in your pleadings? Take out your writ petition. Where have you stated?
Mr. Mahapatra,
My lord, my lord,
the facts are,
my lord,
you approached the court much after your retirement.
my lord.
And you accepted the pension also.
You get the pension also.
My lord.
Under
Whatever
technical-
litigation, though it is not said in so many words by the other side, but fact remains that after the litigation, you are brought into the regular establishment for 12 days.
My-
Then
My
9
lord,
years.
my lord, my humbly submission is that, my lord.
Kindly,
My
so
lord.
this is the problem.
Yes, my lord, yes, my lord.
You dictate, it can be, it can never be completed.
I'm omitting.
So if you take that plea post-retirement, so what, suppose, assuming that you have a case, what can be given to you? Because you are no more in service. You approach the court at the, now you are, what is your age? 70.
My lord.
At the age of 70,
Seven.
You accepted also.
accepted everything.
You accepted pension.
How the clock will
Under
be
Rule
set
6
back?
itself, sub Rule 6.
Some rule
itself.
6.
Because, my lord, the petition is a poor, my lord, class for employment, my lord.
Where have you stated? I am very poor, therefore I could not come to court. Show one sentence. It is not there. I was very poor. I don't have anything else. Therefore, I could not come to court immediately. That is not your case.
No, Lord. Through association, my lord, they have come before this honorable court, my lord, on all Odisha association, my lord. And they approach before this honorable court, my lord. And this honorable court has specifically directed to regularize them in service, my lord. The state government
That you are saying.
went to the appeals court, my lord.
So Mahapatra, that is of 1985.
My lord.
So
And the
that attained finality by Supreme Court judgment. Supreme
trying the
Court
scheme.
doesn't give anything like this.
my lord.
So that was the question to you. If you suppose now you can argue. The best point you can argue is that Supreme Court directed to give.
My case is that, my lord.
Again, the same problem.
My yes, yes,
You are not listening.
my lord.
Neither you are completing nor you are allowing us to complete. Also.
My lord.
Has the Supreme Court given any order in your favor that could have inured to your benefit for getting any more pension? That is the best point you can argue as a lawyer. We cannot go to that side to assist you. So straight away bring to the notice of this court that this is the case where Supreme Court directed that I will get this much of pension. But everything is based on Nityananda.
My lord, I have already prepared a memo, my lord.
No.
And by
memo. Straight away, by which order of Supreme Court you are regularized?
Yes,
Bring
Lord.
that.
my lord, order is there, my lord. I am showing, my lord, the order.
That order is here.
Yes, my lord. All the orders, my lord.
No. On record.
Yes, my lord.
Where is on which page of the writ petition or the writ affidavit?
What is it? My lord,
That ସବୁଜିନିଷ ଏଠି
my lord, I have
ଆପଣ
also,
ଦୋକାନ ଚିଠା ଭଳିଆ ପଢାନ୍ତୁନି କାଗଜ.
No, my
It's
lord.
not a good thing to do.
my lord, I have also, my lord, already,
ତ ଆପଣ କୋଉଠି ସେଟା ରିଟ୍ ରେ ରେଫର କରିଛନ୍ତି?
my lord, it reference,
Why have referred to that Supreme Court decision?
my lord. In annexure 6 series, my lord, of the way. 6 series of the way.
No, hard, my lord. My lord said that all Nityananda has been put across the bar.
Yes, my lord. I have already.
Nityananda, if you rely on Nityananda, Nityananda is directly against you. Look at Nityananda. Read.
Yes, my lord. Yes, my lord.
So you have to look at Nityananda. Can you look at
Yes,
Nityananda,
Lord.
page 17?
My lord.
Qualifying service.
Nityananda is come directly against you.
Yes, my lord.
It supports AG's contention.
My lord.
The first paragraph
My lord.
employs the word, it will be added only for qualifying service.
My lord.
That's the structure of sentence.
So read Nityananda for the fifth line.
My lord.
Which page you are reading?
Page 20, my lord.
Whatever, yes.
Right.
It is order dated 14/1/2004. 14 January.
9/4/2014, my lord.
No.
WC number 14244.
Sir, Nityananda is not that. You are holding some other brief.
That is Nityananda Vishal, my lord.
OA 3020.
Nityananda is
My lord. 3020 C the 2003, my
Annexure
lord.
6 to the Annexure 6 to the writ petition. His first case is Nityananda.
My lord.
So Nityananda is not order dated 14/1/2004.
14/1/2004. My lord.
Wait.
Wait.
3020.
First line.
Yes, but I read that.
You get Nityananda way.
My lord.
Read it, although his petitioner, you are getting it, but your date is not matching, Mr. Mahapatra. You are disoriented. What is the date of the order in OA?
Order in OA 14/1/2004.
Kindly read. Yes, that's the order. Although
Although as petitioner applicant in this case joined as Amin in the job contract establishment of the respondents since 1964 onwards, his service was regularized in the month of August 1977. His grievance is that even though he has been retired in the meantime, the period he has served as job contract employee has not been calculated as qualifying service while his pension was computed. Hence, he has filed this case and read that the aforesaid period should be taken into account.
So just leave it there.
Right.
So there, now look at the page 19 of the, Nityananda writ petition.
Right.
Order dated 9/4/2014.
9/4/2014.
Yes.
Madam.
Read the second para.
Madam. Challenging in the present writ petition has been made to the order dated 14/1/2004 passed by the London State Tribunal, wherein direction was made to take into consideration the period of engagement of the petitioner under job contract establishment while calculating qualifying service and accordingly his pension.
While calculating qualifying service.
While calculating qualifying service and accordingly his pension and other pension benefits due and admissible was directed to be revised. And
so why do you get entire period to be qualifying service?
Because
this
better see.
So can we add anyway? You see now Sudhanshu Jena has been struck down. Nityananda has gone. Even Nityananda. So according to you, what would be the impact of Sudhanshu Jena on this?
My lord, I'm exactly, my lord. I'm coming to that, my lord. In the Nityananda's case, my lord, Nityananda Pradhan case, my lord.
Now look at.
Yes, my lord. I'm coming to that, my lord. In Nityananda Pradhan case, my lord,
has already arrived.
By
Supreme Court.
Yes, my lord. And
so straight away go there.
Yes, my lord.
Apex Court has said about Nityananda itself. Therefore, we need not reinterpret it. Now we can't reinvent the wheel. Wheel is already there.
My lord.
Make use of that wheel for constructing your Rath or aeroplane or whatever you want to. We need not go back. Now Apex Court has interpreted what Nityananda said. That is end of the matter. Because it's the highest court of the country. It may be wrong.
My lord,
but it is, we have to follow that. Under 140.
My lord, in Nityananda's case, my lord.
So look at para 6 of.
Yes, I am coming to that, my lord.
Yes.
In Nityananda Pradhan case, my lord, the TA number 11 of 98 Bhagavan Patnaik has already relied upon, my lord. And Bhagavan Patnaik case, my lord, went to the Apex Court, my lord. And Apex Court confirmed the order passed by the tribunal, my lord. And they all such persons, my lord, have been granted the benefit.
To repeat what they have said and what is there on record.
My lord.
So straight away, don't go to the again history how it traveled to Supreme Court. Now take Sudhanshu Jena, para 6.
Yes, my lord. I am coming to that, my lord. Sudhanshu Jena is the last man. I am coming to that, my lord. And prior to that, my lord, just after Nityananda Vishwar case, my lord, all Odisha Settlement and Consolation Association, my lord, they approached before this honorable court, my lord, against the order of the tribunal, my lord. And on merit, the division bench, my lord, has passed the order directing to count the entire period of service towards qualifying service for the purpose of pension. Then the state government went to the Apex Court, my lord. And the Apex,
Mahapatra, are you dissatisfied with AG's submissions?
No, my lord.
So he has said everything that because you are going to the litigation history. So
no, my lord.
Please look at Sudhanshu Jena straight away, so that it has given everything. So Lord AG has given the how it has traveled to Supreme Court. So look at Sudhanshu Jena. Don't look at me.
Yes, my lord.
Sudhanshu Jena should attract you more than me. Look at para 6, 9 and 10. You can start reading from para 5 actually. 8 also.
Nityananda is fully discussed.
Fully discussed.
Full discussion on Nityananda.
Internal page 54 of the actually runs to hundreds of pages, but it's only cost actually.
Right.
Entire 450 SLPs have been remanded back to the High Court. We got para 6.
Yes, sir.
Kindly read.
All there. Before us.
All the same on 21/10/94, the Orissa Administrative Tribunal, Bhavan Patna versus State of Odisha, TN number so and so on total misinterpretation and the reading of job contract.
All the same.
Madam, the entire period of service, job contract service should be para 6.
All the same.
All the same on 21/10/94, the Orissa Administrative Tribunal, Bhavan Patna versus State of Odisha, TN number 11 of 93 on a total misinterpretation and reading of job contract employees case held that, my lord, held that the entire period of job contract employment,
Interpretation and reading of job contract employees association.
my lord,
94 judgment.
job contract employee held that the entire period of job contract employment should be considered for calculation of pension. This ruling,
What is your response to that? Now in this case,
my
because
lord,
it has been remanded to us. So what is your response to the observation of the Supreme? How do you get over that? To be very precise.
because similar matter also challenged before the Honorable Appeals Court also. In Appeals Court also,
So Bhabatra, since I am.
my lord, my lord,
Matter that.
yes, my lord, I'm,
Don't.
my lord.
Bhabatra, don't go to any other place.
Right.
Because it has complete Sudan there.
Hmm.
So what is your response to the Supreme Court observing this? Regarding Bhavan Patnaik and what is your response to it? Anyway, if you don't want to answer that, fair enough. Kindly read that. You continue reading part 6, please. Bhabatra, can you please?
My lord. Try to tell. All the same on 21/10/94, the Odisha Administrative Tribunal in Bhavan Patna versus State of Odisha, TN number 11 of 93 on a total misinterpretation and the reading of job contract employees union, held that the entire period of job contract employment should be considered for calculation of pension. This ruling was followed by the tribunal when it ordered conclusion of the entire period of job contract employment in calculation of pension in Nityananda Biswal versus State of Odisha, OA number 3020C of 2003. The State Odisha unsuccessfully tried to challenge the decision. My lord.
And Nityananda Biswal has been taken note by the Supreme Court. And Supreme Court has said that is a total misinterpretation of job contract employees. They did further. The State of Odisha unsuccessfully. That is your submission also. The state has challenged. Can you read? You don't have to turn pages.
Yes, my lord. Yes, my lord.
Is this your
My lord.
I'm sure I am with you. Or you are the one. Can you read that? Then the State of Odisha unsuccessful. Read further. That's okay. That's enough.
My lord. All the same on.
You are repeating all the same now 5 times.
My lord.
Okay, AG read twice.
My lord.
We have read 3 times.
The State of Orissa unsuccessfully tried to challenge the decision of the tribunal before the High Court and this court. Clearly, the tribunal had misinterpreted the ratio of job contract employees union case.
What is your response to that? Supreme Court saying the tribunal has misinterpreted ratio of job contract employees union case. Because you have been also relying on job.
No, my lord, that.
So kindly read. No, I'm not saying anything.
My lord.
No. Read further para 7.
All the same, the same tribunal in its latter decision, such in the All Odisha Settlement and Land Consolidation Non-Gazetted Technical Service Association versus State of Odisha, and connected cases on 25/3/2011 considered the amended sub-rule 6 of Rule 18 of Odisha Pension Rules 1992, along with the judgment of the Odisha High Court in Job Contract Employees Union, and dismissed the claim of the association for inclusion of the entire job contract employment period while calculating pension.
This is important also.
This very para 8. How about the read para 8?
Right. Following the principles laid down in Job Contract Employee Union, another division bench of the Odisha High Court in State of Odisha versus Nityananda Das and others, WC number 11503 of 2008, upheld the view of the state and dismissed the other such similar claims. Thereafter, Lord Single Judge of the High Court in Judicial Party versus State of Odisha again dismissed the claim of the similarly situated persons, although the state government was directed to consider if any further concession can be made to the employees. So there is a provision, my lord, under the regulation 114, my lord.
Read further.
No, but I register as the formula. In compliance with the said direction, the state government once again considered the question whether the entire service can be counted towards calculation of pension benefit, and it was again turned down by a speaking order dated 2/7/2022. This order has never been challenged by any employee before any court. Thereafter, in Chintamani Ponda versus State of Odisha, WC number 1 and Pitambara Hota versus State of Odisha, the Odisha High Court again rejected the similar claim of the employees relying on judicial party case. In the present batch of cases, the Lord Single Judge of the High Court relied upon the judgment of the tribunal in Nityananda Biswal and ordered that the entire service period be counted for calculation of pension of job contract employees. The writ appeals are filed belatedly by the state and were dismissed on the ground of laches. We are totally in agreement with the submission made by the Lord Senior Advocate CPS Patwardha that the order of Lord Single Judge cannot be sustained. Moreover, as stated at the outset, the division bench judgment dismissed the writ appeal of the state on the first day itself, undoubtedly on grounds of delay. Had the division bench given them an opportunity, the state would have explained the entire legal position and expertise anomaly in the order of a single judge.
So, making any submissions, what is your next submission after reading para 6, 8, 9, 10, and 11?
Well, all such
Come to sub-rule 6 again. Sub-rule map. Up to 18. Sub-rule speech. Up to 18. Let us read it slowly. I will read for you.
Page 39. The cutoff is the right side, not in the left side.
Let's read 38 first. Let's read 38. Because there is a marked difference in the employment of words. The language of 3 is different from the language of 6. Let us see. We are your opponent advocates. You have to then insist. Okay. Now we travel with you also to some extent. 3 weeks. 3. Notwithstanding anything contained in the largest one Roman of sub-rule 2, a person who is initially appointed by the government in a provincial establishment for a period of 5 years or more, right, is subsequently appointed to the same or another post in a temporary or substantial capacity in a pensionable establishment without interruption of duty, the period of service, here you have to read it. The period of service so rendered in a workshop establishment shall qualify for pension under his rule. Okay?
Well,
The period of service so rendered in workshop establishment. Now let us come to the language of 6. Notwithstanding anything contained in clause 1 and 2 of rule 2, first sentence, say 1 and 3. All right. A person who is initially appointed in a job contract establishment and is subsequently brought over to the post created under regular pension establishment, so much of his contract service period shall be added to the period of his qualifying service in regular establishment, and this is very important, I would render him eligible for pension. The first, the focal point of this rule, the rule maker drafted this rule, you should be made eligible for
pension.
Not that the pension amount payable to you should get enhanced. That is not the option. Otherwise, they would have simply said, once an employee in job contract service is brought on to the post created in the regular pensionable establishment, he shall be paid pension by reckoning entire service. The last question, you cannot amputate a portion of the rule and interpret it. When we hold the English decisions, when you are construing it, how you are construing it? Read all the rules, then get one scheme element, then go to a particular rule which is applicable to it. Read all sub rules, they take out buttons from it, then work out which will come to the word. This is the approach. This is constructive interpretation, actually. It's not just literal interpretation. What it says now, see the textual difference between 3 and 6. 3 does not say would render him eligible for pension. The object of rule 6 appears to be to send you home with the total pension, not empty days, and not to make you rich by giving pension which others will get who are in regular service. That is not the object of this rule. Number 3, you are arguing. 10, 11 would come to the word rescue. We cannot agree because then nobody will come to rule 6 at all. There will be none. All they will come to 10 and 11 and they will stop there. Everybody will get rich. That is not the object of the rule. Because when we see 10 begins with the expression subject to other rules. Subject to other rules means these rules are kept in view with the rules based on rules. Subject to other rules, other rules will say they should have overriding effect on permanent level. Permanent level or a piece of general law. And rule 18, especially 3 and 6 of rule 18 are a special law. Special law overrides the international law. There are many points in your favor also. I'm not saying those points because we are in your favor in those points. But the points which run against you, we have to put it to you to extract more from. Don't get the impression that we are arguing for the state. We want to extract as much filth from you as possible when giving to these seats. And who wanted service settlement organization?
My lord. Or you call consolation.
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 Always settlement and
Consolation. My lord.
You can take on 221. That page only. Nothing of service or service settlement organization. Except in pensionable establishment,
My lord. My lord.
service in survey and settlement organization shall not count unless it is followed without interruption by qualifying service.
Without
So
interruption.
there also even it doesn't give about the entire period of service.
In counting of survey service in survey settlement organization, except in pensionable establishment, service in survey and settlement organization shall not count unless it is followed without interruption by qualifying service.
So yours was a service in a non-pensionable establishment contingent.
No, Lord.
Because-
Contingent, but contingent.
Don't say note everything because you are interjecting without any meaning. Neither you are articulating anything, you are simply interrupting.
Then came to pensionable
Because that is how you are taking benefit of 18(3)(6). Now, according to you, this Sudhanshu Jaina's case, Supreme Court has not taken which decision into account, which is left now for this court or for further arguments. In Sudhanshu Jaina's case by Supreme Court, they have left nothing for consideration.
It has surveyed your High Court. Sudhanshu has surveyed your High Court on the point. Nothing is left.
Because you are saying that no, you see, Mr. Mahapatra, you are saying because it is from you to assist you only.
My lord.
You are saying no, my lord, in this case this has happened.
My lord.
So which case Sudhanshu Jaina has not noted?
Every case is noted.
Including Supreme Court cases, all Supreme Court cases, and where it has said that those do not, by ineligibility dismissal without consideration on merit due to delay, does not lay down a correct precedence, or it cannot be a precedent that way. So which case is left from Sudhanshu Jaina now?
That is
My lord.
Neha Muhammad and Khudi Distillery, two judgments that the doctrine
Already
of
there.
margin does.
Supreme Court has reiterated, but
My lord,
What is that? What you say?
but this doctrine of merger, unless the leave is, there are two stages. Unless the leave is granted, because 136 is not a right of appeal. Leave is
Once
yes.
leave is granted,
Leave is
merger takes
granted,
place.
then the question of decision on merit comes. Otherwise, will not. That would not dismissal in limine. That doesn't.
Will not lay down 141.
Right. Not all the judgments personally I have in Sudhanshu.
Is laid down.
Right. In Milord, all those judgments I had gone one by one, beginning from Justice Ansaria's judgment, because both of us were arguing this matter in justice. So I have scanned each and every judgment from date.
No, according to you,
Right.
what is the ratio decidendi of this judgment? So that this
So Nityanand is no more a good law.
That's-
They say that's
it ends with that.
That's-
Therefore, decide on
they were following, yes. They were following Nityanand. Nityanand Das says contrary.
Contrary.
Iswal says something. The division bench of this.
One is
Yes.
Nityananda, another is Mithyananda. To say
Sure, now, sure, these orders, there may be many such orders also. I don't know how many are pending here.
all we have to
Right.
keep it a bay and decide the matter in the light of
That would
justice.
govern. That would govern.
That would apply to rest
That
of
would
the
apply
cases.
to the rest of it. Once a division bench judgment comes, that would govern. And that would be in the light of this Sudhanshu Jaina, of course.
Anything more you want to say?
My lord. In rule Rule 18, 3 and 6, my lord.
3 and 6.
3 and 6, my lord.
Again, we'll be.
Yes, my lord.
There is no res judicata for reading.
In Rule 3, my lord, Rule 3, it is meant for overcharge.
Correct.
Okay, my lord. Then Rule 6, my lord, is meant for Job contract.
Job contract. Correct.
Government has already framed the rule, my lord. 15,597, my lord. For regulation of DLR, NMR, job contract, and also work charge employment. And in that particular rule, my lord, and that rule has been framed pursuant to the direction of the Honorable Supreme Court, my lord. In that rule, they have stated that after completion of 10 years service, all such employees will be regularized in service. And first preference should be given to work charge employee.
Where is that rule?
Yes, I have produced. But since, so in two categories of employees, my lord, are similarly situated, and once benefit has been given to work charge employees, and counting the work charge period of service towards qualifying service, so only some period of service of job contract has been counted and not the entire period of service, it creates discrimination, my lord.
Already another set of employees have been granted full pension.
Granted full pension.
Means their full service is counted.
Counted. And another thing will be...
How many of them?
Well,
approximately.
18.3, discriminatory quite issue.
That Supreme Court itself did not take that.
That's the problem.
It's talking of work charge.
No,
The problem is
work charge is different.
my lord, no, my lord.
Job contract is different.
My lord, pursuant to the direction of the Honorable Supreme Court, they framed, my lord, they framed the...
Have you read Sudhanshu Jena?
Yes, my lord, I have read, my lord.
So kindly look at where Supreme Court has answered this.
Supreme Court said both are two different, they are poles asunder. They are not same.
But that rule has not been brought to the notice.
What the Supreme Court said, can we be more wiser than the highest court of the country? It's not like that. We are work in a hierarchy thing. We may disagree, but we cannot defy the judgment of...
My lord, the Honorable Supreme Court in other cases also, in similar nature also, has dismissed the appeal filed by the state government.
They have asked us to file issue.
And they have been granted the benefit.
But they have asked them to review.
Also will review.
Mr. Mahapatra,
Review petition has also been filed in Sudhanshu case, my lord. Also.
Mr. Mahapatra, actually the difficulty is that
Case, my lord, review petition has been filed.
kindly read Sudhanshu Jena. Supreme Court has left nothing for imagination to argue. As far as Odisha High Court is concerned.
My respectful submission is that till date, now review in both the cases are pending. So, and the judgment passed by the Sudhanshu Jena case, my lord, has not come finality, my lord. Now, review is pending.
Kindly look at Mr.
Before the Honorable Supreme Court, my lord.
Para 15, look at Para 15.
Because such facts was not brought to the notice of the Honorable Supreme Court, my lord.
No, so that we cannot say that Supreme Court will or will review. That's a different.
Because the
Don't argue Mr. Mahapatra,
my respect.
You see, we cannot say that since the Supreme Court may look at a review, so that's not that's not part of the legal, argument. Look at
Yes, my lord. I have already gone through, my lord.
To decide for that.
My lord, there is a Mathis committee report, my lord. So far as job contract employees are concerned.
Kindly, Mr. Mahapatra, don't be in a hurry. You just let us complete Sudhanshu Jena.
Sudhanshu Jena, my lord, I have already read.
So if I read, so kindly assist us in reading also. Look at Para 15.
My lord.
Because we can't continue like this.
And for that, my lord, for that review petition has been filed, my lord.
So that will record, you can say, but you must understand what is the consequence of recording such. But look at Para 15 of Sudhanshu Jena. Why we are closing the brief also in court? That doesn't. No, you are in YouTube. You are not holding a brief.
Kindly
look at 15.
My judgment is here.
No, look at 15.
Yes, my lord.
Internal page 62.
My lord.
Yes. So read it.
As stated earlier, there is a clear distinction between the employee who are in work charge establishment vis-a-vis those who are in job contract establishment. The distinction becomes obvious from a bare perusal of sub-rule 3 and 6 of the rule 18 of the Odisha Pension Rules 92, where it is given that work charge employee who have worked in the establishment for a period of 5 years or more without interruption and subsequently appointed to the same or another post in temporary or substantive capacity in a pensional establishment the entire period rendered by him or in workshop establishment shall qualify for pension under the Orissa Pension Rules 1992. Well,
There is no my lord there. Compare this with the provision.
Yes.
Read further. Or I will, if you ask me, I will read. I have no difficulty.
and
So compare this, then I am reading it. Compare this with the provision relating to job contract establishment, for whom it has been specifically stated that in case of job contract employee, after she is brought in pensionable establishment, only that much period as job contract service shall be added to regular service as would make him to qualify or eligible for pensionary benefits. And so they have noted the distinction.
However, the para 15 million, para 15 has not taken note of the government resolution dated 15/5/97. But now in the review million, that part no. My lord, in the review million, now review has been filed million.
What we can do is,
My lord.
since the judgment which you have read will have implications, Mr. Acharya, since the judgment which you are going to render has got implications, both of you file your short written submissions.
My lord. My lord.
In the meanwhile, we also go through everything once again.
My lord.
We reserve the judgment.
My lord.
Your submissions should reach us
My lord.
within 3 days.
My lord.
All right.
My lord.
Heard reserved.
Deeply obliged. I am deeply obliged.
Very, thank you.
Well, item 12 and 14 I was mentioning earlier, my lord. They belong to work charge employees.
Work charge.
Yes.
Two are work charge. Work charge, then work charge are there covered. Yes. Work charge.
So what says, so why you have come to court? Because that rule is there.
I have no.
That is the instruction of-
They have filed the lead appeal.
Right?
Government has filed the lead appeal.
Appeal.
No. What says the High Court has held that
Even Supreme Court has held
that 18(3) is applicable.
applicable.
18(3).
So,
Then how are you going to sustain the appeal?
so it is less than 5 years or what?
No.
The only exception could be that if he works less than 5 years, then better not.
They by their own affidavit filed.
Yes,
in the-
they are appellants.
We can leave it aside. What's just.
We'll pull all of them. How many of them are there? Work charge.
First, maybe today we are having 2 million, and I will ascertain that how many work chat. All can be listed.
That's what. And how many of these matters?
Job contract.
Job contracts.
Because Supreme Court takes note of so many, the Lord AG said 450.
Give all of them because it will have its own impact.
Yes, definitely. We will give the entire list. So far as work charge, I will give the list, and so far as job.
Segregation is required.
No, let it be. Let them be posted here. We can segregate.
Yes.
If they are posted before the court, we can segregate them. So which are the work charge matters now?
Lordship may direct the registry.
That's what I will do, but you will have.
Registry cannot know actually. Registry doesn't have that kind of a
Expertise is not there.
data. I mean,
You will know because you have filed the
because you have filed. Or
which is that work
and
charge?
at least
Serial number.
this 48 pages of Supreme Court.
12 and 14 minutes. 12
and 13.
14.
12 and 14.
Make a list. That's what. This 48 pages of Supreme Court's cause title in Sudhanshu Jain, please prepare a list which are the corresponding writ petitions. Because you are the appellants there in SLP.
Even here they are the appellants.
Even after remand you are the appellants also. Correct. So where are those 450 cases? And out of 450, how many are work charge?
On serial numbers?
But 12 and 14 minutes.
12 and 14, along with all other connected matters relating to work charge establishments.
Which have been remanded by those.
In the light of Apex Court decision in Civil Appeal SLP Civil number 2146 of 2024. State of Odisha versus Sudhanshu Shekhar Jena decided on 21 February 2021. The appellant state and its official to furnish the list of such cases to enable the office to post them before the court immediately. The registry also shall do its own homework based upon the decision of the apex court cited above. Next paragraph. Let us see all of them. Perhaps may not survive because of the Sudhanshu matter itself, your appeals may not survive. They have upheld. And if you succeed there, these matters have to be allowed.
Either of them.
They cannot go together.
83
They are
and
like mongoose
86.
and cobra.
83 and 86 has been distinguished in para 15.
Because of 15.
And Mr. Mahapatra, spend some time in preparing your notes. The notes they will give after the list.
No.
Within 3 days.
3 days that we will not wait because we may forget whatever you have argued.
The record document. Sir, the record
I have taken such my plan. Getting provisional pension in pre-revised scale, my friend.
No, that is another cause of action.
Yes.
What we will do is
They are not.
we'll leave other cause of action for you.
Yes, and they have not paid after 9. They have not implemented the order. Not.
For information.
My information is the person who has retired on 36/2018 is getting the pension from 1/7/2018. Initially, now
2018.
1/7.
Because 1/7/2018. Because he retired on 36.
Yes. It's no right of.
It's a provisional pension.
Yes.
But why provisional pension? After you deduct this 5% of the
span of period, because of the paucity of time, I could able to get the information that there are another proceeding which is pending, and this has been challenged before this Honorable Court. And the period from 2000 to 2003, for a 3 years period, that has not been regularized. For that purpose, the final pension could not be granted, and it is in the process.
Another petition is, which is that case?
Well, that I will search for the information because I am busy in this matter. I could not in details.
Regarding another case, I have no information.
There is another case.
Maybe you may not be the council also. You may not be the
You might have engaged at some other.
I have no information on that.
Our notes we are making in your case. This intra-court appeal seeks to call in question a learned single judge's order dated so and so, whereby
811.
petition appellant's WP number so and so has been negatived. First, in the said writ petition, appellant employee, now a pensioner, had called in question the order of punishment in a disciplinary proceeding, whereby 5% recovery from the pension for a period of 1 single year was directed. Kindly be seated. Vasantu. Vasantu.
5% withholding of pension.
Withholding of. Sorry. First, next paragraph. Learned counsel appearing for the appellant urged the following points for consideration, seeking invalidation of the impugned order. First, small Roman 1. Under Rule 7. Under Rule 7(1), of Pension Rules 1992, awarding of punishment of withholding of pension in the absence of proven loss to the government is impermissible. First, in support of this submission, he relies upon the coordinate bench decision of this court in Pratap Kishore Das versus High Court of Orissa, 2009, Supplement 2, OLR 377, paragraph 30.
15 and 16.
12,
15, 16. 15, 16. Paragraph 15 and 16.
15 and 16. First. Number 2. There was a coordinate proceeding taken at the hands of a learned single judge in WP number so and so, wherein a direction was issued to accomplish the disciplinary proceedings in a time-bound manner, and further application of the other side seeking extension of the period was rejected. So that being the position, after the lapse of the period prescribed by the court, further proceedings could not have been held at all. Number 3, the disciplinary proceedings were initiated after long lapse of time, and therefore, in the light of Apex Court decision in Vigilani, the same was hit by doctrine of latches, which aspect the learned single judge lost sight of. Number 4. The appellant had not committed any misconduct in as much as he had only carried out the instructions of the superior, and further that he had not scripted PAR,
Performance appraisal report.
PAR, as sought to be made out by the other side, but had only placed the service records on the table of jurisdictional authority. First one. Next paragraph. For the admission, but that's very important. Yes, sir. State. Learned counsel appearing for the next one, appearing for the respondent, resisted the appeal, making submission in justification of the impugned order and the reasons on which it has been structured. First one, learned counsel controverted both the propositions and the factual statement made from the side of petitioner. First, having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. A. The first submission that under Rule 7(1) of 1992 rules, there could not have been punishment of withholding of increment for any period in the absence of proven loss to the government is difficult to countenance. First off, the reason for this is not too far fuller. The said provision reads as a next point. The language of sub-rule 1 of Rule 7 is as clear as Gangetic waters. First off, it is easily discernible that the said rule contemplates two classes of cases. Visera. One, the cases where misconduct in general is committed, and the cases where the misconduct committed occasions loss to the public exchequer. First off, in the former, any punishment, including withholding of pension, can be ordered, and there is no limit as to how long such withdrawal should endure and how much of the pension should get deducted. First, in the later, the total amount of pension, the total amount to be recovered by way of withholding of pension shall be limited to the loss occasioned to the state. First off, this subtle difference having been noticed, we cannot agree with the first submission. Next paragraph. The reliance of learned counsel for the appellant on Pratap Kishore Das would not much come to his rescue. First, paragraphs 15 and 16 of the said decision read as under. The clarity of law, although could have been more, the clarity level of law declared could have been more, cannot be much disputed. First, be that as it may, the above paragraphs cannot be read to say supra in variance with what we have stated in the paragraph supra. First of all. Secondly, the observations in these two paragraphs appear to be more case specific than law laying down. First, it hardly needs to be stated that the case is an authority for the proposition that has been laid down in a given fact matrix of the case, and not for all that which would logically follow from what has been so laid down. First off. Next paragraph. The next contention of learned counsel for the appellant that the time limit having been prescribed in one case of his, and application for extension of the limit having been negative, there was absolutely no justification for continuing the subject disciplinary proceedings is bit difficult to countenance. First up, the time limit prescribed cannot be read as a Euclid's theorem. First up, while construing judgments of the courts, one cannot keep his common sense in cold storage. First up, time limits cannot always be read as deadlines. First up, therefore, first added, the court which prescribed the arguable time limit did not, in so many words, interdict the disciplinary proceedings which were pending at that stage of the matter. First up, therefore, it is difficult to countenance this contention. First, the added contention that the disciplinary proceedings were initiated very belatedly also suffers the same treatment at our hand. First off, there is no prescribed limitation period for initiating disciplinary proceedings by their very nature, subject to all just exceptions, into which case of the appellant does not fit. First off, Apex Court, in a number of cases, including in Vigilani, has observed that whether the proceedings of the nature are barred by delay and laches depends upon the facts and circumstances of each case, and that there is no thumb rule. First one. Next paragraph. The last contention of the appellant that his client did not commit any misconduct and therefore the other side ought to have examined the cited witnesses to prove the guilt to the hilt, again is liable to be rejected. First off, appellant in so many words had taken up a stand before the disciplinary authority that he had accomplished the alleged act only on the instructions of higher up, and therefore he ought to have proved such assertion to be true. First off, it hardly needs to be stated that an asserter of fact suffers the burden of proof inasmuch as the negative cannot be proved. First off, no explanation is offered by the appellant as to why he did not call the higher official who had allegedly instructed him to do the task in question. First, absolutely no evidentiary material was placed before the disciplinary authority to vouch the assertion that there was such instruction from the higher ups. First of all, that apart, whether there was such instruction and whether there was no such instruction essentially belonged to the domain of disciplinary authority who has formed an opinion after duly holding the subject proceedings. There is no instruction. First, the inquiry officer in so many words recorded a finding that there is absolutely no evidentiary material to substantiate the assertion that there was an instruction from the higher up in compliance of which the alleged misconduct has been perpetrated. First, lastly, it is for the parties to decide whether cited witnesses should be examined or not. First off, it hardly needs to be stated that in matters like this, a writ court cannot run a race of opinions with the executive, there being traditional constraints with which they operate. First, in the above circumstances, this appeal being devoid of merits is liable to be dismissed, and accordingly it is. First, do you want us to treat the last contention? Well, whatever grievance as to the nature and quantum of pension now being drawn by the appellant, he can work out elsewhere in accordance with law. First, the observations herein above being confined to disposal of the appeal shall not cast their light or shadow on any such proceedings.
What we have been discussing is that when you filed a OA in tribunal directed to file a counter. They did not file counter, or whatever happened. So that proceeding was pending or disposed of?
Proceeding was pending.
So yes, so I have understood it correctly. That I informed His Lordship. So High Court directed for disposal of the DP.
DP.
Did the tribunal in any manner decide regarding the DP?
No.
Then what happened
to that case?
Suppose that DP has been set aside, or either way, it has been confirmed by the tribunal. Then what happened to that?
Because he retired and continued the proceeding, that tribunal case, I don't remember. It is I think it is dropped.
He doesn't know that circumstance.
Then we
I have no information.
What happened?
No, we understand your predicament also, we understand, but what happened there?
I don't remember.
Because we challenged that proceeding itself. Distributors?
Spreading them.
Very small lordship. Item 44 that is regarding that they are the result of MBBS student. The lordship is today, but this comment item 44. NLP lordship, any certain lordship with face address that matter can taken out to the lordship. 44 lordship. Medical student by the
So you inform the other side and mention it whenever it is listed.
Today is listed. Item.
Sir, next. Today, should we sit beyond? So whenever,
so that
so that all of you, the request is, as it fell from my lord, that all matters have to be distributed, all are after notice. I think we have crossed orders, went to again hearing, again now started the other matter.
One heavy matter
was there. So this will happen every day.
Let it be sorted with the press admission hearing. So that it can.
So what best you can do, his hands are very tight. No, we are not directing, then why not for all? Only for Mr. Dolay, why not Mr. Malik?
Medical last 15 months lordship is out of, and it's with result
out of the campus now.
Lordship now already passed out lordship, but the certificate, they are not releasing the certificate.
And we will have that matter on 24th.
Lordship, careful lordship.
24th.
In case I must so
item 26. Lordship last time fixed this matter today, finally. But let's sort that maybe even because the petitioner is not getting salary since 96, man.
Since 96?
Yes, ma'am.
Salary?
Yes, ma'am.
But he is working.
Some days before, he has already retired, crossed the age of superannuation.
Cross superannuation, in the third week of August.
My lord, item 34, my lord.
So though it is retaping.
Yes, my lord. Unlike petition, they have, government has filed the writ appeal. My lord.
It is in your favor.
It is, yes, originally with this case was in favor, my lord. And after contempt notice, they have preferred an appeal. So short date may be given time.
We have bit difficulty. In August, we will complete it.
Well,
We have only some heavy matters. In August, we become little
last week
easy.
of July, we are also not fixed.
Last week of July.
My lord.
Last week of July. Someday.
My lord, item 34, my lord. One retired person who is not getting pension, my lord, since 2 years, my lord.
Retired person not getting pension.
No, my lord.
That's the only case.
Only case, my lord.
Criminal case pending.
My lord, no, my lord.
No criminal cases.
No, my
secondary
lord.
proceeding.
No, my lord. State filed the writ appeal due to that he is not getting any pension.
After 2 weeks, some after second week, third week of July.
Obliged, my lord.
Item 25, I have filed one IA to keep one seat vacant. In this case, my lord, to keep one seat vacant for associate professor animal reproduction. In this case, madam, they have applied the reservation policy wrong, for which I was.
Let us see. We'll have the third week of July. Yeah.
My lord, item 28. My lord, that is Matta. 9 years staying away from each other.
Judgment is against me. In the meantime, my lord, the judgment which was referred, that has already been reversed.
Reversed by the apex court.
No, reversed by the division bench.
Division bench.
My lord. So basically,
earlier decision was followed by the learned single.
My lord. During the pendency of the writ appeal,
Second
that
week
is
of August.
my lord.
Item 35, my lord, so it may be taken up next.
So item number 24. So matter challenge number 24. So matter challenging the quantum of the quantum. Quantum I have challenged.
Quantum.